Any mention?
Please, Lordship, I beg to mention item number 23, Lordship.
Number?
23. 23, Lordship. I beg for some more time, Lordship.
Lordship, for the petitioner. No objection, Lordship. 32, 2 weeks, yes.
Highly obliged, Lordship.
Highly obliged.
Your Lordship, I beg to mention item number 15, Your Lordship. Senior counsel was present, but he's still not in a position to take up this matter today, Your Lordship. Hence, I
saw him in the morning.
Yes, Your Lordship, he was there, but he's still not in a position to take up the matter, Your Lordship. It's not really well.
Yes, 2 weeks.
It's a similar matter for item number 25, Your Lordship.
No objection. No objection. 2 weeks, yes.
Would you like, Lordship?
That's it. Yes.
Your Lordship, I pray for item number 21.
Still not well, Mr. I'm still on leave.
Yes, Your
Still on
Lordship.
leave?
He came for the...
He's still on leave, huh? Yes, 21. After 2 weeks, yes.
Obliged.
And for the private.
Lordship, I beg to mention item number 26. The conducting counsel, Mr. M.L. Nampur, is indisposed.
Anyone indisposed? Other side?
Sir Demnat, I've already taken consent.
2 weeks, huh? Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 24.
24 on whose behalf? On behalf of Mr. Ganguly? Or who's appearing for the this?
Lordship, of petitioner.
24, you're for whom?
And for the respondent, Your Lordship.
Number?
Number 24.
24 is mandatory. It's MECL matter.
24 is MECL matter. Are you sure you mentioned right matter?
MS Smart Banyang, Your Lordship.
You're appearing for which respondent?
For the bank.
The bank?
Yes.
Yes. Why do you want time?
Your Lordship, as per the last order, has been reflected that the matter will be listed tomorrow on the 2nd of August, Your Lordship.
You're correct.
But it has been...
Please order sheet.
I'm sure there's a matter, there's another bank matter.
Well, some urgency in the part of the...
Your Lordship,
There's
by
no bank or
mistake.
party, my lord. Here only the
Yes?
deliberations are
Mistake, Your Lordship. I was actually for the...
Is the matter between the MACL and the where they are insisting on the hearing?
Yes, Your Lordship. I made a mistake. Actually, I'm for the Punjab National Bank, Your Lordship.
In which matter?
This matter is not listed.
I make a mistake, Your Lordship.
It's for tomorrow listing?
Tomorrow. I think it's tomorrow, Your Lordship. I haven't checked the cost list for tomorrow. I just checked today.
What is this?
Sorry, Your Lordship. I apologize.
No, this is for today. Yes. Be careful, be careful. Yes.
Supplementary list, item number 1.
The motion amend list.
Sorry. Name list, item number 1.
My lord, this matter relates to the registration of the Nokma sheet.
Yes.
My lord, here I may take lordship attention to page number, my lord, page number 15. This is the application filed by respondent number 5.
1 second. 15.
15, my lord.
Where's Mr. Day? Right.
My lord, so this was taken up. We filed the objection, my lord, the learned deputy CEM without framing the issues. My lord.
1 second. This is whose application is this?
My lord, application filed by the respondent number 5, the Sangma, my lord. Now he was seeking for registration of the Nokma sheet for respondent number 6 and 7. So we objected, my lord. There was a hearing, and the learned CM court CM supposed to allow the party to adduce the evidences, formulate the issues.
No, you filed an objection.
We filed objections.
Then what happened to the objection?
My lord, the objection was, my lord, the place. My objection application was dismissed, and the
Where is
application
that
filed.
dismissal?
My lord, we come to page number 22. 22. In relevant paragraph, may I
22?
read? My lord. Paragraph 23, the last paragraph, may I read, my lord, to save lordship time. Page 23.
Yes.
My lord, this court find it fit to dismiss the objection of complaint filed by such and such on being withdrawn, and the complaint objection of Dasing A. Sangma. This is me, my lord. For one of merit without abusing process of court and without causing injustice to the petitioner and invoking the power vested upon me, I hereby allow Srimati Sons and such, Sri Sons and such, to register as a Nokma of the Sons and such. So my objection was dismissed, and the other application was accepted, and prior to respondent number 7 and 8, 6 and 7 were allowed to register as a Nokma. So therefore, my lord, this order was passed without framing the issues. Being agreement, we filed the appeal.
It's not a question of family issue, it's not a dispute or nokmaship. It's only a claim for registration.
Right.
And if he's satisfied that yes, they have the support of the Maharis, and what prevents them from rejecting the objection?
My lord, the Dores Sangma case, it should be.
Dores Sangma case is on a different footing. It's when there are two competing parties. Suppose like they were already in the juridical chart,
Right.
and then they were removed, and then someone else comes in, and so they said the fundamental principles has been observed. That's all.
But
That yes, by giving adequate opportunity. Now, how do you see not given adequate opportunity?
my lord, here also, my lord, there was no hearing, no issues were framed, and the CM court passed this order. Agree with my lord, we filed
See the nature of the order. Just read this third paragraph in fourth paragraph. Sorry, in page 22. The
My
last
lord,
paragraph.
this
page
court is
22.
of the opinion that the petition of Sons and such deserves to be allowed, because in the spot inquiry report, it is clearly stated that Srimati Nimi Sangma, who is present female Nokma of the Sons and such, are king, being without any issue, children has adopted Sons and such by way of sons adoption, following the custom and practices of Garos, and they rightly deserves to be registered as Nokma. And this application being placed after observing all the necessary formalities, and has placed the petition through Sons and such, one of the Sons and her husband, Sage Mara, as Nokma of such, has fulfilled all the customs and practices of Garo in regards to the registration of the Nokma, and as far as the complaint objection filed by is concerned, he has submitted that only after the inquiry and after the withdrawal by the original objector, and therefore I do not find any merits. And on further perusal of the record, it is found that Sri Sangma was also present in the meeting, my lord. Meeting place in regards to the registry of Sons and such, my lord. Marak as Nokma along with the applicant and other clans people. And for the same, I do not find any weight in the complaint filed by Sri Dasang Sangma after inquiry, and not the satisfaction of this court to intervene the same, my lord. Now, what happened?
That means that there was an earlier objection, then after that
lord,
they withdrew, and you, who are you?
My lord, we are also the member of the clan.
Who are you?
The clan member, my lord. The clan member. And those.
Yes.
So
Yes,
at
Mr.
least the lord should be kindly issue notice. Let them respond.
We'll take instructions.
I don't think it's anyway. I heard Mr. H.L. Chang, counsel assisted by so and so issue notice returnable in 3 weeks. Mr. S. Deb is present, accept notice on behalf of
1 to 4.
response 1 to 4. Pressure take steps to issue notice on the remaining respondents within 3 days.
Yes.
Just after 3 weeks, yes.
I'll do that, Lord.
Supplementary list item number 1.
It doesn't matter. None appear the petitioner list after 1 week.
Item number 2.
My lord, this is the second round of litigation whereby earlier round of litigation, lordship has passed the order. Lordship, kindly see page number 44 of my petition. 43 was the report after we moved this honorable court, and lordship issue notice to the respondent. The deputy commissioner conducted the inquiry, and report was submitted page number 43. Lordship, kindly see. May I read, my lord?
Yes.
My lord.
Yes, please read.
It said, as for the verbal discussion with Sen Gupta on examination of WPC number such.
Which page you reading?
Page number 43.
43.
43. The report submitted by the DC office.
Yes.
Madam. WPC number 256 of 2020, Mosumi Coast TV, A versus State of Meghalaya and others. The office was advised to conduct one round spotting inspection since no complaint has been received so far by the Office of the Deputy Commissioner, such. Spot inspection was conducted on such and such, my lord. Now findings may come to that, my lord.
Yes.
Existence of drain measuring about such. 5.2 meter of the drain is covered by the concrete slab constructed by respondent number 5, such. Respondent has extended the cantilever beam on the top of the drain to provide a slab cover for self-purpose use. Total of 6 concrete slabs have been constructed over the drain measuring about such. The wall constructed. So this was my complaint. Well, the public drain was there. The concrete slab was constructed.
Yeah, what happened? Whose municipality?
Well, Lordship passed that note.
What action is taken post in this inspection report? If nothing's been done, that means that we absolutely unacceptable. Heard Mr. Chairman Council, assisted by also issue notice returnable in 2 weeks. Yes.
1, 2.
Who accept notice for whom?
Lordship, 1, 2. 1 and 2, your lordship.
1 and 2, Mr. N.D. Shula is present. Then AG also. And for 3 and 4, Mr.
Notice will go to R5, your lordship.
Stop. Next paragraph, Mr. Sunrise Senior Council has submitted that is in spite of inspection report, which appears at page 22.
43.
43. Wherein the respondents number 3 and 4 have undertaken to take necessary action. Nothing has transpired which has compelled the petitioner to approach this court again. Stop. Next paragraph. Mr. Firam Nongwi, another counsel for 3 and 4 to obtain instructions within 3 days. Yes. This accordingly.
May I take respondent number 5 step for the respondent number 5 steps?
That's all he said.
Item number 3.
Yes.
May it please your lordship. Your lordship, this matter pertains to claim of family pension, your lordship. This is second round of litigation.
All second round, right?
Yes, your lordship. The
Where's the early order?
earlier order is at page 35, your lordship. Your lordship, it was withdrawn with liberty to file if so advised because there were talks of settlement between the private respondent and the petitioner. However, no settlement could be arrived at.
Who appeared for the private respondent before?
Your Lordship, Mr. Z.A. Siddiqui.
Who is he?
I'm not sure, Your Lordship.
So what happened now?
Now, your lordship, again being aggrieved because I'm the legally wedded wife, your lordship. He was under my care. He was diagnosed with oral cancer. I was legally married in the year 2011. He was diagnosed with cancer in the year 2015. I've been the one taking care of him.
Service?
Yes, your lordship.
Okay. Heard MSCB Sawyan, Learned Counsel for the petitioner. Issue notice MSZ Inong country is present on behalf of respondents number 1 to 3.
1, 2, 3 and 5, Your Lordship.
1, 2, 3 and 5. Notice to respondent number 4 and 5.
4 and 6.
4 and 6, yes. Consider AD within 3 days or by personal service. Yes, list after 3 weeks.
Obliged, Your Lordship.
Item number 4.
Wait, please, Your Lordship. Lordship, here, my lord, there are 3 petitioners, my lord, who are essentially aggrieved by the non-declaration of the result, my lord, to a certain post of enforcement inspector under the Transport Department, which was advertised in 2017, Lordship. The entire process culminated into a interview. However, the results were never declared, my lord. Till
Yeah, one of the candidates went for the interview.
Lordship, yes.
So what happened?
If I may take your
When
lordship,
were the exams held?
Lordship may kindly come to page 43, Lordship, which is the advertisement.
Yes.
Page 43, my lord, advertisement dated 26th April 2017 was issued, my lord, by the MPSC.
Serial number?
Lordship will find it at page 45, my lord, serial 9. Page
Okay.
45, my lord, serial 9. Enforcement Inspector under Transport Department. Qualification, my lord, is graduate in any discipline from any university. Age limit is there. 4 posts, my lord. 4 posts were
When were the
advertised.
exams conducted and when were the interviews held?
Lordship, the screening test, my lord, the first stage was held in 11th of December 2020. It could not be held in between because of COVID and all that. Eventually, it was held in 2020 December, lordship. Thereafter, my lord, the interview was conducted on 16th and 17th of December itself, and the result.
2020.
Lordship may kindly come to page 66, lordship.
May it please,
1 second,
Your Lordship.
Mr.
If I interrupt Your Lordship,
1 second,
because
Mr.
there is a stay order, Your Lordship, in another one writ petition, where Your Lordship was pleased to recuse in that case, Your Lordship.
Lordship may kindly see that is enclosed, sir.
This is
Lordship, this is
where's the stay order?
Lordship, this in the
That
case.
is enclosed, my lord, at page.
No, you have not a
It's there, sir. At page
page 1.
page 67, my lord. Page 67, lordship. The order is there.
Yes.
Then you filed for vacation.
No,
You
my lord,
pleaded this case.
my humble submission is, lordship, that this stay which was granted by the in the single bench, my
Ordered
lord,
benches.
is not in connection with this post which were advertised where we are claiming,
Who will
lordship.
examine it? Yes, sir. But Mr. S.
I think that is.
You come up
That is-
instructions first. Yes, issue notice. Mr. Andish Railway AG with MS Alconi is present. Accept notice on behalf of all the respondents.
Respondent 1, my lord.
Respondent 1. Who else are there?
MPSC is there, lordship. Respondent 2.
Yes. Notice to issue to the other respondents. Only 2 respondents. Yes. Within 3 days. Just that after 2 weeks. Mr. Andu Shalai, next paragraph, the AG submits that the result has not been declared due to the pendency of a related matter wherein stay or interim orders are operating.
It's the same advertisement only, Your Lordship.
Yes, sir. Stop, which is counted by Mr. S. Dev, consular petitioner, who submits that there is no connection. Such instructions to be obtained by the AG within 2 weeks.
Lordship.
Yes, sir.
Apply, Your Lordship.
Highly obliged, lordship.
Item number 5.
May it please Your Lordship.
1 second, Mr. Second, let the file come.
After a long time, Lordship.
Yes.
Before COVID, I was here regularly. So, Lordship, the petitioner.
15 years we are appearing against
Yes,
each other.
that was 2009 to 2011 story.
But now we are in the
Should
same.
be a cause of celebration. Yes.
So, Lordship, the petitioner before this honorable court is, Lordship, he is a mobile service provider having about 43,000 mobile towers across the country, and out of which 137 are before this honorable court. In 2013-14, he faced some problems, this company, Lordship, and went through a process under the Insolvency and Bankruptcy Code, Lordship, 2016, and also participated in the corporate insolvency resolution process. There are a lot of applicants. The applicants, basically, if you look, the names are always Reliance. So the petitioner is the Ambani Group, the Anil Ambani's company, Lordship. Now it has been taken over by the Mukesh Ambani's Reliance, Lordship. There is an approval order of the NCLT Bombay, Lordship. That was in 2020.
Page?
Page 218.
On 18.
Yes, 218. It starts at that page, and if Lordship is pleased to come to the relevant portion at page 234. May I read this place, Lordship?
Yes.
The application B and the same is allowed. The resolution plan submitted by Reliance Digital Platform and Project Services, which we represent, Lordship, now, through its division infrastructure projects annexed to the application, is hereby approved. It shall become effective from this date and shall form part of the order. It shall be binding on the corporate debtors, the employees, members, creditors, including the central government, any state government or any local authority to whom a debt is respect of payment of dues arising under any law for the time being in force is due, guarantor and other stakeholders involved in the resolution plan. Then Roman 5, henceforth no creditors of the erstwhile corporate debtor can claim anything other than the liabilities referred in paragraph 6 of this judgment. In paragraph 6, Lordship, during the process of this resolution process, public announcement was made, notice was also sent to the Meghalaya State Electricity Board, Lordship, whether they have any dues regarding page 101. 102 is the notice. 102. It was issued to the accounts officer, billing officer, State Electricity Board, Power Distribution on 25th of July 2019. All the details are noted here, and Lordship would be pleased to come to page 103, the middle paragraph. The supply of essential goods, or number 2, the supply of essential goods or services to the corporate debtors as may be specified shall not be terminated or suspended or interrupted during the moratorium period. The moratorium shall be effective till the date of completion of the CIRP. As per the provisions of the code and the order, undersigned notes that you have been supplying electricity to the corporate debtor. As per section 14.2 of the code, the supply of essential goods and services to the corporate debtors cannot be terminated or suspended or interrupted during the moratorium period, as electricity constitutes an essential service within the meaning of Regulation 32 of the Insolvency and Bankruptcy Board of India, Regulation 2016. In the light of aforesaid, I request you that the existing electricity connection of the corporate debtors should not be disconnected during the CIRP, and it would be lead to breach of moratorium. In the light of aforesaid, in the event you have any claim against the corporate debtor which have not yet been submitted, you are requested to submit the same to the RP along with the necessary proofs substantiating such claims in accordance with the provisions of the code. And now Lordship will kindly come to page 107.
Did they reply to it?
They did not respond to it. We made paper publication also, that was also done. Paper publication, Lordship, at page 101. 8/5/2019. At no point of time they have responded. So Meghalaya's name is there in 107. Assam State Electricity Board also name, all these northeastern states electricity boards names are finding place and figured in this chart. There is no serial number. It is from about 8 from below. Meghalaya State Electricity Board. So now the issue is, Lordship.
What happened now?
They have issued this impugned order at page 38. In fact, before this order in the month of January and February, we requested them because the effective date of transfer was of 22nd December 2022. So the Mukesh Ambani's Reliance took over and the transfer date started from 22nd of December 2022, and we have deposited more than 400 crores, 4,000 crores for taking over this company. Now, and in the month of January and February, we made request to them that kindly give us more additional connections. They refused and declined to give us the connection, saying very clearly that until and unless you give all the outstanding dues, we are not going to clear it. Somehow we did not object it and we did not raise anything. Subsequently, this order came on 12th of June 2023, page 38.
Yes.
To Sumit Soe, a subsidiary Reliance Jio. With reference to the subject cited above, I am to bring to your kind notice that there are 116 number of mobile towers having power supply with outstanding electricity dues of more than 5,000 rupees each, and the total outstanding dues against this consumer is 70 lakhs so and so, as on 31st May 2023. Further, there are 16 number of mobile towers which are already been disconnected, and the total outstanding dues as on 31st May 2023 is 2,74,807. There are also 18 number of mobile towers having power supply with outstanding electricity dues of 5,000 or less or without outstanding dues. The list of live etc. is given.
Okay, now your case is that the moratorium, they can't come and realize.
No, the moratorium is over once the approval order was given. So there is no moratorium. Now, Lordship, kindly the last paragraph. This is most damaging order, Lordship.
Yes.
It is requested to kindly make necessary arrangement for payment of the dues of live consumers having outstanding dues of more than 5,000 and that of the disconnected consumers having outstanding dues within 15 days from the date of issuing this letter, failing which it may be compelled to disconnect the power supply of the mobile towers having outstanding dues of 5,000 or below, or no dues as per the list appended at Annexure 3 in compliance of regulations so and so of the Electricity Code of 2008.
One thing, Mr. Saike, what about the current bills?
Current bills we are all paying, Lordship. Everything we are paying.
Only regarding outstanding dues.
Only outstanding. Now they are not. Yeah, we have given a representation. We want to know the date of the dues, when it was due actually.
Before the resolution.
Exactly, Lordship. Lordship is absolutely correct. So we have no difficulty. This 3 crore is not the issue. The issue is the principle, whether this due is actually legally admissible against us or not. That is the issue. The law is well settled by the various Supreme Court judgments, High Court judgments. Lordship is well aware of the law. They should have made the claim at the relevant point of time. Once that bus is missed, Lordship, they cannot now come. Supreme Court in number of cases has laid down the law and reiterated law for infinite times, Lordship.
Yes, Mr. You are bidding for the cooperation.
Now, Your Lordship will see that the submission before Your Lordship is that the resolution plan has been approved. And after approval of resolution plan, the claims which are prior to the approval of resolution plan cannot be agitated and cannot be raised, and it is barred by law. That is what the argument has fallen from. Kindly see the resolution plan, my lord, which my friend has pointed out at page 218, which is approved, and ultimately it was approved up to Supreme Court, but that is what I have read in the paper book. 218, my lord, and kindly come to page 218 is the resolution plan approved by National Company Law Tribunal at page 218, and the terms of approval, my lord, at page 234. My lord, and at serial number 3 at 235, small Roman 3, approval of resolution plan shall not be construed as waiver of any statutory obligation of the corporate debtor and shall be dealt by the appropriate authorities in accordance with law. Any waiver sought in the resolution plan shall be subject to approval of the authorities concerned. So this approval, my lord, will not come in the way of the the secured debtors, my lord, secured creditors, to make a claim.
What about one then?
One, if your lordship will see there.
Just read one.
One, application B and same is allowed.
Yes.
The resolution plan submitted by Reliance Digital Platform and Project Services Limited through its infrastructure project annexed to the application is hereby approved. It shall become effective from the date and shall form part of this order. It shall be binding on the corporate debtor, its employees, members, creditors, including the central government, any state government, any local authority to whom a debt in respect of payment of dues arising under any law for time being enforced is due, guarantors and other stakeholders involved. So there are two types of debt which is envisaged under the IBC code. One is that the debts which are arising out of usual code. Second is of the statutory dues. So far as statutory dues are concerned, my lord, I have a judgment directly on the point saying that so far as statutory dues are concerned, they are liable to, they are not subject matter of, because rider, small Roman 3 is a rider, my lord, which takes care of the statutory.
So then what about 5? 5 then militates against 3.
No creditors of corporate debtor
can't claim anything other than liabilities.
Can't claim anything other than
liabilities are laid out para 6.
Yes, if you also will see the liabilities also, kindly see the liabilities at page 226.
See, one thing, yes, Kumar, that at that point of time a notice was issued.
Yeah, and kindly see, notice was issued to whom? To Meghalaya State Electricity Board, which was not in existence. We are all separated. There is no notice to me, and my lord, kindly see, there is no notice to me. This notice is to board. My friend has pointed out at, and your lordship, I don't know what is the connection of Reliance Jio with the notice. My lord, kindly see at page 107. Page 38, notice which my friend has read out at page 38. Now, Summit Digital Infrastructure Private Limited.
Yes.
So now I don't know what is the legal status
of this. Status has been taken over, Mr. Saike, by
Summit was not the company which was there in the IBC.
Summit they are part of us. These are all the parent company is that
What is the situation now? Now Jio has taken over all this.
From everything. Everything, Anil Ambani's, all the towers, all the services
My
are
friend
taken
is
by.
right. Everything has been taken by the Reliance Jio. But the question which falls for your lordship's consideration is that if the under the IBC resolution plan has been approved for company A, for B you can't do it. And my argument is the statutory dues. You kindly see the recent judgment of the identical circumstances dealing with this aspect of the matter. Because this identical issue fell for consideration of the Honorable Supreme Court in this case. Paragraph 2, my lord. Short question raised by the appellant in this appeal is whether the provisions of IBC and in particular section 53 thereof overrides 48 of GVAT Act, which is set out herein below. Tax on fast, so statutory dues, my lord. And the submission you lordship will see at paragraph 24. In this case, paragraph 24, my lord, in this case, the claims were invited well before 5th October 2017, which was the last date for submission of claims. Under the unamended provisions of regulation, the last date for submission of, under regulation 12.1, appellant was not required to file any claim. Read with regulation 10, appellant would only be required to substantiate the claim by production of such materials as might be called for. The time stipulates are not mandatory, as it is obvious from sub-regulation 2 of regulation 14, which enables the interim resolution professional, as the case may be, to revise the amount of claims submitted, including estimates of claim made under sub-regulation 1 of the regulation, as soon as might be practicable when he came across additional information warranting such revision. In this case, at the cost of repetition, it may be noted that there was no obligation on the part of the state to lodge a claim in respect of dues which are statutory dues for which recovery proceedings have also been initiated. The appellant were never called upon to produce materials in connection with the claim raised by the appellant towards the statutory dues. The adjudicating authority as well as the appellate authority misconstrued the regulation. On behalf of appellant, it has been argued that there were proceedings initiated state. So after that, my lord, the proceeding has been taken note, and then kindly see paragraph 48.
Yes.
A resolution plan which does not meet the requirement of subsection 2 of section 30 of IBC would be invalid and not binding on the central government and any state government, any statutory dues or other authority, any financial creditor or other creditor to whom debt is in respect of dues arising under any law for time being in force is owed. So this resolution plan, my lord, your lordship would require consideration. This matter requires consideration. In
yes, I think
absolutely, lordship, and section 238 of the Act Code, 238.
That will have over any other act for time. That is
173 and 174 of
and our resolution plan was finally approved by the Honorable Supreme Court also. 238. Provision of this code to override other laws. The provision of this code shall have the effect, notwithstanding anything inconsistent therewith, contained in any other law for the time being in force or any instrument having effect by virtue of such law.
My lord, only one thing, my friend is fair when he said that 3 crore rupees is not an issue. The principle, principle is the issue. And I am all for adjudication of the principle. Yes. But we are a small state. 3 crore rupees they can give it to me.
Council assessor by
much more. Let us run the business.
You should notice
much more.
You accept note on behalf of all. Yes, sir.
Why 2?
One. Yes, Mr. K. Barachaji, Leonard GA.
1 and 2, I'm there. 1 and 2.
Mr. Samad Kumar, Leonard AG, appearing for both respondents. Yes, it's present with Ms. Arko only and given in accept notice stop. The matter concerns the challenge to a notice dated
12th of June
2023, whereby the respondents have demanded for payment of outstanding dues against mobile towers, which have been incurred in the years. It was incurred in.
That is what, Lordship, they have not disclosed.
No, that's one thing which will be deciding factor also. Yes, only which have been incurred by the petitioner. Stop. The ground of challenge is that as the as the petitioner was already admitted to insolvency with effect from 7/5/2019, and a resolution plan which was duly approved, which was submitted, has also been duly approved, and the respondent, pro forma respondent, right?
Yes.
Number
3 and 4.
3 and 4 have since taken over the petitioner company. Any rights or liabilities subsequent resolution are barred by the application of the Insolvency and Bankruptcy Code 2016. Stop. Next paragraph. Mr. A. Kumar and AG submits that the claim of the respondent is saved by the resolution plan itself, and has also placed a decision in support thereof, that the same being statutory dues, the petitioners are liable to satisfy the same as per the demand. Stop. As a matter requires further consideration, principally on a point of law, this is a matter for admission hearing when?
Maybe 4 weeks, let them file an affidavit also.
This match for admission hearing. After, just give it a time. After 4 weeks.
4 weeks.
After 4 weeks, stop. The respondent 1 and 2 to file affidavit in the meanwhile. Stop. It is further provided that till the next date, no coercive action shall be taken against
at least
the.
some amount. Let them deposit 50%
Shall
because in
one submission,
these are
Lord.
the electricity dues, my lord. We
Yeah,
are
what, 4
already
weeks?
dealing with
4 weeks.
we are dealing-
No coercive action be taken against the petitioner.
At least let them.
Till the
let
next
them
date.
current dues. Let them. Current
dues we are paying.
Till next date,
Let the
stop.
state.
Till next year, stop. It has been submitted by the Mr. D. Segia that the current dues are being satisfied.
And we are also applying for few fresh connections. This is business for
That will
Meghalaya.
not include order. That's all, yes. This accordingly also.
Some observation, Lordship.
That will see later. Our time admission here.
Yes, Lord.
Yes.
Highly obliged, Lordship.
Where's the complaint? This is a complaint.
This was the complaint,
Where's
my
the
lord,
general?
which was
This online, Your Lordship.
Yeah, general.
Lordship, the petitioner was supposed to produce a copy of the complaint to show that indeed condemnation was sought for.
Lordship will find that at page 41 of the complaint, Lordship.
I can't hear you. What are you saying?
Lordship, on the last occasion, petitioner was required to file a copy of the complaint filed with the local Ayuktha.
Right. He produced that today. Yes.
To convince this honorable court that in fact the condemnation was applied for. Now I believe
The
condemnation.
Because
Where?
Lordship will kindly come to my lord, para 37 of the complaint at page 41, Lordship.
Para 37.
Para 37 at page 41 of the complaint.
Yes.
Lordship, if I may read, my lord, that the cause of
Yes.
action of the instant case first arose in the year 2013 when the respondent number 3 had issued the utilization certificates. The respondent number 2 had released the funds. Again, on 30/6/2014, when the complainant filed the complaint representation before the respondent number 1. On 21/3/2017, when the Honorable High Court passed a judgment and order dated so and so. On 8/9/2017, when the inquiry was conducted without giving opportunity to the complainant, who is also the petitioner, my lord. On so and so, when the Honorable High Court passed its judgment and order in WPC 144 of 2022, whereby granting liberty to the complainant to approach this honorable forum and seek remedy, and as such, there is no delay and or latches on part of the complainant in preferring this instant complaint, and the limitation period under section 53 of the Lokayukta Act 2014 may be waived, and the delay, if any, may be condoned.
See, Mr. Dev, 8/9/2017, and you came on 28/11/2022.
No, but the petition was pending before this court.
Where's 17? From 17?
Lordship, yes. Right from
Where is that?
2016.
2017. Where's the petition?
Lordship, may kindly have
Where's the order?
The writ petition, my lord. In fact, in the complaint also it is there.
Yes, from the complaint show.
Lordship. Lordship, may kindly come to my lord, page 108, 107, Lordship.
Of the complaint.
I'm sorry, 108, my lord, of the complaint.
This is not writ petition 2017.
No,
it's
Lord.
writ petition 1 of 2022.
No, Lord, page 108, annexure 15, my lord, WPC 400 of 2016 with contempt case C23 of 2017.
No, but if you say it was heard in 17 inquiry, then this writ petition 2016, and how?
No, Lordship, what happened was initially we filed a representation.
You supply a copy, let them file affidavit. There's nothing here. It's just heading.
The matter was always pending before this court, my lord, and the inquiry was done on directions of this court, Lordship.
Yes, a copy of the complaint filed before the locoyukta has been produced by the counsel for the petitioner, and the same is also made. Given copy to you?
No, Your Lordship.
I'll supply, my lord.
Why?
Or is required to produce, my lord. I'll give it, my lord, today itself.
You file by affidavit by tomorrow.
Very well, Lordship.
You take this back. What is written? Stop is directed to file the same by way of affidavit with notice to advance notice to the respondent. Stop. Mr. S. Jindal, praise me allowed to file a short affidavit with regard to the condemnation. Yes. This after 3 weeks.
3 weeks, my lord.
There's no explanation, Mr. David. And the writ petition 2016. You see, inquiry in 17, you not heard. That means when the writ petition was pending, the inquiry was done.
It was done in the direction of this court, my lord.
Then
thereafter the inquiry was set aside.
Yes, then
Again we.
What remains? After 17, you slept, then you came back 22.
No, immediately we filed.
And you withdrew it and said, I'll take appropriate action. You file a fresh complaint.
No, Lordship. I may be allowed to
For
explain.
schemes that are 2013.
No, the list of events, my lord, I'll place it, Lordship.
Very good. Yes. Next.
Your Lordship, I'm appearing for the petition on behalf of Jay Schiller. This is a matter which is pertaining to the excessive force which was used by police personnel against the petitioner, and the fact that they've barged into the house of the petitioner without any warrant and misbehaved.
And the fact that he threw out an old lady into the street.
And they are a tenant, my lord.
Yes. So what do you want now?
Affidavit has been filed today, Your Lordship.
By whom?
By the state
on the last
respondents, Your
occasion, we
Lordship.
have submitted
Where's the
this in the
affidavit?
report. Well, I believe there's some defect. I've been called. I don't know.
There's still defects here.
I believe I have received message also
Yes,
from the registry. So some correction.
MS
needs to be
Arcoli submits that though the affidavit was filed today itself due to some defects that have been pointed by registry, you will to correct the same. Yes, list after 1 week. Yes.
Your Lordship, I'm also praying if we may be allowed to file rejoinder.
You get the affidavit first. Let it come on board first. Yes.
Main list item number 2.
My lord, this matter, Lord, may I seek some accommodation? Take up next week.
Same as IBBF.
My lord, this border fencing, man.
Indo-Bangla border fencing. So I said IBBF.
IBB.
Yes.
IBB. Sure.
What happened? Are regarding compensation that been received?
No, not yet. Not yet, man.
Yes, Mr. Sen. What?
We have raised some preliminary objections, my lord. Those would have to be heard first.
Mr. H.S. Sangri, so please some accommodation be given as due to personal difficulty. According to this matter after
a week, man.
After 2 weeks.
2 weeks.
Yes.
Obliged.
Item number 3.
My lord, this case respondents is yet to file affidavit, my lord. Enter, my lord.
I've received instructions, my lord.
What instructions have received? That deep tube well?
Yes, that is the case. That is the case.
So is the instructions negative or positive for the petitioner?
Instructions in the sense that he could not execute the work, my lord. Very poor quality of work and delayed also, my lord. So we had no choice but to
blacklist him.
Blacklist him. And terminate his
You're against the blacklist.
Blacklisting, that is my grievance, madam. And because of this order, none of the other organizations are accepting me. Yes,
When
it
did
is
you file
a-
an affidavit, Dr.
2
Mozika?
weeks time I'll file.
They file it in 1 week.
The drafting hands are little.
Drafting is okay after 2 weeks. Yes, Dr. Mozika, please submit the instruction will receive and please be allowed 2 weeks time to file affidavit. So, prayer allowed just after 2 weeks for affidavit.
Item number 4.
My lord, reply.
Complied.
No, my lord, reply has been filed, my lord.
Rejoinder.
My lord, rejoinder.
Start.
My lord, the contempt was issued because of the petition was filed due to non-compliance of the order passed by the division bench for grant of the pay and parity to the petitioner, my lord.
Yes.
In the affidavit in opposition, my lord, the respondent number 2, contemptant number 2 has filed.
This is order dated April.
My lord.
Yes.
My lord.
What happened?
They have preferred an SLP, but no stay is till date has been obtained of that judgment. So that is still in vogue.
Yes.
Ballot in para 7 of the affidavit we stated, ballot. This is a very comprehensive exercise required to be done in respect of 700 personnel, my lord. Rank structuring, cadre review, my lord. Para 7 of the affidavit.
Was the time limit given?
My lord.
Time limit was given only.
In the order, seems to be violated.
4 months was given.
That was in April 2022.
The next division bench order.
You didn't annex it?
We have annexed, my lord. The DV order, my lord, it is at
20th April.
It's not an issue. Division bench order.
Where's the order? In a contempt application?
page Annex 2, page 26, my lord. कैसे बोलते हो यार?
This is the order.
My lord.
Read appeal.
My lord. My lord, the operative part is at page 37, page para 24, my lord.
Six months from date.
Within 6 months, my lord.
Oh, really?
There's no contempt. See, the thing is that the time is elastic. The thing is that within 6 months, feeling which monetary benefits and monetized value of other benefits will carry interest simply 6% per annum.
My lord, even that also, my lord, time frame they should have initiated or they should have prayed before
So the thing is that, see, they've gone for SLP.
My lord.
Now we see due to 6 months. Feeling which, now monetary money will be, now the longer it takes, the more beneficial it is to you. Correct? Then what contempt is there?
My lord, that will be, since it is since 2019, they have, till that time, my lord, single bench we...
No, see, read 24, it is hoped it is hoped, not that it's directed. It is hoped that the entire benefit be extended to the writ petitioner respondents and to all similarly placed personnel or started within 6 months from date. Hoped, okay, it is hoped, not shall. Feeling which monetary benefits and the monetized value of the other benefits will carry interest at the simple rate of 6% per annum from till the date. See, the thing is that if you do 6 months, no 6% interest. But now they've gone beyond 6 months, so you're getting 6%. So should we proceed the contempt and you waive the 6%? Or
That's the instruction of the client, my lord. If it will be
we take down, yes, sir. This contempt application has been filed alleging violation of the order dated 24/2022 passed in Miss Case bracket WA number 15,019 in WA number 10 of 2022 and other connected matters. Stop. Next matter, Mr. Arja submits that by the said order, the respondents were allowed 6 months' time to extend similar service benefits to similarly placed personnel of some rifles, which has not been complied with by the respondents. Stop. As such, he prays that appropriate contempt proceedings be drawn up against the said respondents. Stop. Next paragraph. Dr. N. Muzika, learned counsel for the respondent, has submitted that the exercise will consume some more time, and that moreover an SLP has been preferred against the order for which the respondent is awaiting the outcome. Stop. Next paragraph. A perusal of the order stated to have been violated, particularly para 24, is reproduced here and below. Page 37, para 24. Next paragraph. A perusal of the above noted para reflects that the division bench had passed a conditional order wherein it clearly states that failure to comply with the order within 6 months would attract other consequential benefits to the writ petitioners. Stop. Next para. In view of the facts of the case, stop. No contempt has been made out at present at this stage, and the matter is closed. You tell your client not to make so much of hurry. Yes. Next. Yes.
Item number 5.
Please, Your Lordship. It's the election matter, my lord.
What is this? 711 matter?
Lordship, yes. My lord, we have only received they have filed a reply to our reply, my lord. They filed an application under 711.
Filed their application to the show cause reply, Lordship, today only.
You file?
Reply to the show cause reply, Lordship.
Replication to the show cause? Replication or reply? Replication means what? This is a typo here. Replication doesn't mean reply to reply. Yes, ready?
We will argue on the next date, my lord. Today morning only at 10:45 we are served with this copy, my lord.
Lordship, this is not a writ matter where we serve first the copy, Lordship. We have to first file it in the court, Lordship. Then only
yes,
we.
That's all right.
This is
so fair enough. He just received the copy. Yes,
my lord.
Reply to the show cause.
It'll come up next week, my lord.
Yes.
After 3 weeks.
Reply to the show cause filed by the petitioner under order 7 Rule 11 has been filed by the respondent number
3.
Number 3. So the same is taken on board. So next premise, list is matter after
a week, my lord.
After 2 weeks, yes, for consideration. Yes.
Obliged, Lordship.
Item number 6.
Please, Your Lordship. Lordship, with regard to the letter they have submitted, the state respondent, there is only, they have mentioned the family pension is under process, my lord. So there is no calculation what amount I have to, what is the entire amount.
May I please, Your Lordship?
They should file an affidavit.
Where's the letter?
My lord,
see, if it's a pension matter,
yes, my lord.
We don't want to deal the matter with affidavit and all. If we are satisfied that the thing is being is in the process, so whatever you can, you take for a time being.
Lord, they have actually in the letter.
We'll give a time period for them to complete the process.
Yes, my lord. They have mentioned for succession certificate. So, my lord, without having any amount, what is the amount?
So where is that?
They have submitted.
Yes, 23rd June 2023.
Yes, ma'am.
Yes.
So may I please, Your Lordship, only thing they have said that after closing of the case, let the petitioner approach them, they will provide her the statement of accounts and they can take the succession certificate. Because he married in 2005 and joined in 2010. But service book, her name is also not there. So how they...
Yes.
Yes, my lord. This is the duty
The
of
thing
the
you go-
respondents.
No,
my
no.
lord.
You have to go to the office and get.
My lord, yes, my lord.
The diverse details to you. Have you approached them?
Lord,
Like what is the?
My lord, I have approached. I filed a representation there in 2020, my lord. Thereafter, they have not disposed the representation. Then I approached director, my lord. So that representation is also pending, my lord, till today. Then I serve with a notice, my lord.
We'll do one thing.
Service book is at page 19, Your Lordship. Her name is also not there. So, how officially?
You're the only wife.
Yes, my lord. With 2 children, my lord.
Nothing is reflected in the service book page in 19.
This is
Page 23 is the his biodata is at page 23.
Where's that? Yes. Okay.
Only his father's name is there. Father's name.
Where's the father's? They see. The thing is that unless he's made a nomination, there is no column for writing wife's name. It's only father's name, or mother's name, husband's name, or mother's name. That's all. So why should he enter wife's name? Is not given there.
Yes, Your Lordship. Nomination.
Where's nomination?
Next page 24. Just a minute. Marital status. Serial number 5, Your Lordship. Page 24. In our page 4. To certificate in attestation. Serial number 5, Your Lordship. Marital status. Nothing. It is blank, Your Lordship.
Your husband died when?
On 15, my lord. 2015, my lord.
Why he didn't disclose that he was married to you?
My lord, I have no knowledge, my lord. He was appointed in 2010, my lord. And
he married in 2005.
Married 2005,
my lord.
So better, Your Lordship, let her approach the office.
Ready to approach. We filed the application, my lord. We filed the application to director.
Mr. Hassan.
And my lord,
if you get relief, you will get quicker relief than waiting for affidavit.
I've prayed for interest also, my lord.
So how come his...
First, at number 1, please try to get how much amount is due before going for interest.
My lord, yes, my lord. My lord is correct.
You've not even got, the cart before the horse. You've heard the saying, no? Putting the cart before the horse. So, you haven't got the horse or so, you already want to get the cart.
This is the due amount, my lord, legally due amount, my lord.
The stated case of the petitioner is that she was the wife of late Salim Reza, Selimreza, who was serving as an assistant teacher at Garodubi, Grodubi, Government LP School in West Garo Hills. Stop. The petitioner's husband, he died in harness.
Yes, my lord.
The petitioner while in service expired on 21/10/2015. Stop. 2015, and though the petitioner had filed representations before the respondents for release of retirement benefits, the same has not been forthcoming till date. Stop. Next by Mr. S.K. Hassan, Senate Counsel for the petitioner, has also submitted that in spite of representations being filed and the petitioner approaching the respondents, she has not been made aware about the amount of terminal benefits and family pension due to her. Stamp. 1 second, wait. Next paragraph. MS Barachaji, Leonard Counsel, Leonard Common Advocate, has produced a letter.
Dated 23rd June.
No, there's has relied on a letter dated 23rd June 2023, which he had produced on the earlier date, wherein is indicated that the pension and other benefits of the deceased employee are under process, but the same has not been finalized due to the unavailability of a succession certificate to substantiate the claim. She submits that it is as soon as succession certificate is produced, the respondent authority shall compute and release the amounts due. She further submits that as in the service book, the petitioner's name does not appear anywhere as a nominee. The respondent authority at this stage is not in a position to release the amounts without proper verification or an order from a competent court of law. Next paragraph. Considering that the matter involves the release of pension of a deceased employee to the rightful heirs, in this case, rightful heirs, this court deems it fit to dispose of this petition at this stage itself by directing the respondent authorities to examine the representation filed by the writ petitioner and also intimate the terminal benefits due to enable the petitioner to file apply for succession before the competent court. It is expected that the petitioner be provided with the details within
15 days.
Within 15 days from the date of order. Yes.
One gratuity for a sum of rupees 26,000 already paid to
whom?
Provisional. Petitioner has already received. It is in.
So let's get then that will go in. Then if you paid to her, how? Yes, on what basis you paid?
That is the question.
This is already. It is there, Your Lordship, in page.
No, it is there. Why do you pay to her that you say that you doubt she is a wife?
This amount I do not know. They have given.
That is why the
provisional amount. They have written only provisional amount.
It's released.
Yes,
you've been paid.
Yes, yes.
They have
third page.
deposited to the bank account of the petitioner.
So which is called especially in the light of the fact that the writ petitioner has already been in receipt of the provisional gratuity amount payable to late Salim Reza. Next one. In the event that some doubts arise or the representation not disposed of, some doubts arise as the petitioner is able to take appropriate steps in accordance with law.
Yes.
Leave it open. But why have they released and then?
Yes, my lord. They have already released.
If she is a wife,
they examine and they can release now.
Matter stands closed.
7.
Beginning of the type, which one of the last line? Yes, but how about that before the next date? Like now. Yes.
My lord.
But the pleadings are complete, my lord, in this matter. The file have given reply also.
I filed a
Ready?
My lord.
Ready today?
My lord.
SOS has been issued, he said.
Well, that will be effective from 1st September.
In spite of the 1st September, my lord, it's going to be there, my lord. My lord, the case is that, my lord, the petitioner has, after the cancellation 2019, my lord, no fresh application has been filed by the petitioner for opting for voluntary retirement, my lord. The perjury has been committed by the respondent authority. One I have given in my rejoinder, my lord. My lord, if I take you to my lord to.
This is after 1 week.
My lord. And in the meantime, no coercive action should be taken.
No, what course after? Till you're not supposed to move till 1st September.
My lord, till because.
Okay, yes. The pleadings are the party submitted pleadings complete. Said as the matter is of some urgency, this is matter for the orders after 1 week. After 1 week.
For hearing, my lord. Hearing an order, my lord.
No. After it's an order stage.
Okay.
Yes, it is. And endeavor shall be made to dispose of the matter on the next day. This matter for the orders and endeavor shall be made to dispose of the matter next week. This accordingly also.
My lord, one observation, no coercive action.
What observations?
My lord, observation can be, my lord.
Till next is expected that till next date no course of actions shall be taken against the.
Till 1st September, no course of action.
Till 1st is expected 1st September no course of action will be taken against the petitioner.
My lord.
Item 8.
Lordship, in this matter, I have received the affidavit filed by respondent 3 and 4, Lordship. 1 and 2 I have not filed yet.
You want rejoinder? You won't file rejoinder?
I will.
Your Lordship, I'm praying for 2 weeks' time, Your Lordship, for the
For what?
For the affidavit in opposition. For respondent
From 3 and 4 they filed. 1 and 2 you have not filed.
State has
Who's appearing in this matter?
I'm appearing, Your Lordship, 1 and 2.
Is that non-concrete given here? Yes, sure. Look at order sheet.
Yes, Your Lordship. I was not available, Your Lordship, on the last date due to some personal difficulty.
R. Kolni. You're appearing which respondent?
3 and 4.
Who are they?
They're the school secretary and the principal.
When did you file it? This matter was filed when?
April 2023, Your Lordship.
Then? Why is after taking so long?
It's 2 weeks'
August?
time, Your Lordship.
Is instruction received?
Yes, Your Lordship.
Let's see them.
Your Lordship.
What's the matter about?
The government is willing to give them, Your Lordship, provided the school gives us all the papers, Your Lordship. They have not.
What do you say in
given
the
us-
affidavit?
Yes. They're supposed to
Received by
forward
whom?
Documents, the original documents of the schools were received by the petitioner's son.
What's the connection with your son? Yes.
Lordship, the
When did your husband die?
2016, Lordship.
16. Yes. The son took the benefits?
No, Lordship, no.
Your Lord,
To peruse the matter, Lordship, he took the reconstructed service books.
Let's see
and other-
affidavit where what do you say?
What should be para 9 and 28?
Para 9. Another matter goes slowly. Where's the service book now? Is it in your custody?
Lordship, no.
Then would the statement remain para 9?
Yes, Lordship. Actually, the whole thing is about the tracing of service book, Lordship.
Then?
Actually, these documents pertains to the applications made for representations made. All those.
And how does the Respondents Act if the service record is not traceable?
Service record is available with this school itself, Lordship.
Say, who's your son? Where's acknowledgement?
Annexure 9, Annexure 2 at page 9, Lordship. This is a received copy, hence 5 copies, page 10. Balram Shubedi have received.
What do you have to say to this?
Lordship, this is.
But why do you give him service records?
Lordship, that's the point, Lordship.
To pursue the matters, Lordship, he himself comes to the school office and he have asked for the records.
But what kind of school is it? It is your duty to calculate everything and send it to you. How can you give it to the son? What is the son doing?
Lordship, son is a businessman, Lordship. Actually, Lordship, if I may, Lordship, these documents pertain to the representations made.
You don't know about that. What
Lordship.
documents are there? If there are no more documents, see.
And the service book also is specifically
Look at this.
mentioned.
Receipt of documents, certificates of date Motila Joshi, a retired and expired teacher of Northma Nepali LP school, and nothing is left in his custody of school.
Lordship, service book is not specifically mentioned, and Lordship, and school. Why would the school give? Because it should be in the custody of the school, Lordship, and.
They even intimated to the respondents. So, loss of parcels book from Motila Joshi. It can be constructed.
It was actually Lordship, it was.
This is a pension matter. I thought maybe begin directions that. But then if your son is taken and what is done with the papers? Where is he?
Lordship, he's right now not in Shillong, Lordship.
Let him appear in court. What is done with the papers? What right did he go and take the papers?
Lordship, I mean, but my claim is that.
We're not bothered about your claim right now. Your claim is first within your family
Lordship,
settled things.
I have not collected the son has not collected the service book, Lordship.
He's not collected. What he signed is this his signature?
Lordship, if you may see, Lordship, the service book is not specifically mentioned. It was only the paper representation made that they have taken that, Lordship.
If there are no more papers in custody of the school, you don't know how the schools operate. He might have given the entire thing. Now, for the fall of your son, you're trying to lay blame on the school.
No, Lordship.
Then?
Right from the beginning, my son was claiming that
Mr. Pandey is to
Your Lordship.
obtain appropriate instructions with regard to the receipt of papers from the school by his son. What's his name?
Balram Subedi.
So failing which he has to appear in court personally to answer to why, what right do you have to go and take the papers? And you also, what right do you have, why do you give all the papers away?
Your Lordship, my instructions.
What are the instructions?
Your Lordship, the school is supposed to submit all the papers. Then only, Your Lordship, we can.
Of course.
Proceed. Until now, they've not done that, so that's the only problem, Your Lordship.
I thought, no. Mr. Pandit to obtain instructions with regard to the papers that have stated to be collected by his son. You get all the copies which have been. Where are the papers? You haven't seen them also?
Lordship, no.
Then?
The papers are only the representatives. I have seen the papers which are representative.
Mr. Pandit makes arguments. You have come to this court seeking directions, correct?
Lordship.
Before you come, you should stand on a firm ground.
Lordship.
Not come knowing that your son's taken the papers and come and try to get orders from the court.
Lordship, humbly, Lordship.
And you withdraw it and file it afresh.
Service book was not part of the documents which were received, Lordship.
That's what you're saying.
Lordship.
Then? Thought, no? With regard to the nature of papers that were obtained by the son from the school, into the affidavit filed by the response 3 and 4, just up to 2 weeks.
Item number 9.
That's not the way. Courts being compassionate, because of its service matter, doesn't mean that you just. Yes.
I have instructions that yesterday the petitioner was called to join his duty and to execute the agreement. The issue which survives is the pending dues, pending
not
salary.
Here.
My lord, whatever salary he was entitled on the last round in litigation.
Because
My lord,
my case is, my lord, that my agreement was never terminated.
but my lord, so far as the term remains, we have cleared the salary, my lord. And the salary amount was also reflected in the order.
That issue was kept open in the last round also. My lord, kindly have the order caused by your lordship. My lord, at page 36 of my petition.
Yes.
It reads, my lord, petitioner has filed his instant writ application.
He said that it's been released and you accepted under protest.
Under protest, my lord, because they have paid only this particular amount for 3 months.
That is the
My
agreement
claim was,
remains,
my lord, during
You
the
file a suit then
subsistence.
for damages or for recovery.
But that observation may be made, my lord, liberty may be granted.
Already that time you accepted the same under protest for a prejudice to his other rights.
Yes, my lord. So that has not been resolved till now, my lord.
What is the amount you see you're due, which has not been paid?
My lord, with effect from
Is
May.
it for the period you're working or not working?
Working, my lord. Working, because my agreement was still in subsistence, my lord.
You were working that time every day?
Yes, my lord.
No, what will
And
be
their
amount?
claim is that the agreement automatically got expired, my lord. While the terms in the agreement, there's a clause of automatic renewal. So that question has never been resolved. So, my lord, either we'll have to, my lord, they'll have to file affidavit in this writ petition, my lord, or I'll have to come a third round, my lord.
my lord, the agreement also says that it can be terminated, my lord, at any time. However, my lord, the agreement expired in the month of August, so he was last serving the department in the month of May. The dues from May to August were cleared, my lord, despite we have not rendered any service. So, my lord, in that manner, the case
Let
was...
us leave that issue open, my lord. I'll come the third round.
You go. If that is a disputed fact whether you work or not.
It's not disputed, my lord.
They say that, see.
My lord, kindly have page 25. This is a typed copy of the contract. Which part? My lord, page 25, para 1. I'll read the fourth line, my lord, of para 1. Authority and shall remain in service for a term of 1 year, commencing from so-and-so, August 2019, and is subject to automatic annual renewal.
Where reading that?
My lord, the fifth line of para 1 at page 25.
Page 25, para 1, the party, the first part.
Yes, my lord, that paragraph.
Subject to annual contract unless there's a negative assessment of performance of the contract worker. Okay.
Automatic renewal, my lord. So,
And my lord, number 5
this
also
is not
talks about
undisputed.
termination.
This is not disputed, my lord. It's part of the document, my lord.
No, did you
And
issue
there's
any
no
termination
termination.
order?
My lord, there
You
was
never issued any
unfortunately,
termination.
my lord, no termination
No,
order was
that
issued.
is your lapse.
We are not conceding, my lord. But he was stopped from coming to the work, my lord, because he was not attending regularly. There were some
No,
complaints.
but any reports are there from the reports?
My lord, that
Not a single
because since no
notice.
affidavit was filed at that point of time, so considering the COVID situation, we have also considered the salaries, and we have also
And you paid your arrears also. Why are you satisfied with that?
and we are
What is the
refreshing
amount
the
you're
agreement
claiming now?
also.
My lord, with effect from
How much will
May
it come
2020, my lord.
to? How much will it come to?
52, my lord, 52.
It
Salary,
will be
pending
52
salary was
it
52,000
will be
approximately.
quite a bit, my lord. Quite a bit. Because upon execution of the new agreement yesterday, it is only on the execution of new agreement that the old agreement lapses, my lord.
My lord, if I may suggest, my lord, if my friends, the petitioner, considering his situation, my lord, they can make a representation with regard to that, my lord. Let
That's
the,
why,
let
my
the
lord, I'm saying
corporation
I'll
may look
come
into
back
that.
third round, my lord.
Let the
We withdraw this
representation,
one then.
my lord. However,
You don't
this
address
matter,
that issue.
this agreement, with the new agreement being, my lord, executed, this petition can be, my lord, disposed of.
It's submitted that as a new contract has been signed with the board by the petitioner. The issue independent petition doesn't survive for consideration, and the same is the proceedings are going to stop. Accordingly, the matter stands closed, leaving the petitioner to seek other remedies for any other grievances that he might still harbor
In relation to his pay, my lord.
in relation to his arrear pay stuff.
No, my lord,
File a
salary has
presentation.
been paid, that is incorrect.
No,
His
in regard to
salary
his
has been paid.
grievance. I'm not
Yes,
saying
my-
that is
no, my
regard to
friend-
grievance. With regard to his grievance of arrear pay, arrear salary, this one. Let him file a representation. We're not going to go to that. Then when he comes again, then we know what to do.
For affidavit, my lord, I'm praying for some more time.
For the 3 weeks time granted to one is to file affidavit as per it is. As per it for the 3 weeks time.
11.
May it please your Lordship. Lordship, pleadings are complete in this matter. Matter may be posted for hearing.
Affidavit, my lord. We have received a rejoinder affidavit, my lord.
This party submits the please complete. This is a matter for hearing usual causes. Yeah, contractual matter.
My lord, yes. Cancellation of debt.
Yes, my lord.
12.
What in consideration is this one?
This matter is in the process of resolution, my lord. 3 weeks' time is granted. Hopefully, we'll come back with the resolution.
May it please, Your Lordship, in the meantime, Your Lordship, the GE of Dijan, Panitola, and Nakagi, Satogaon, Gauhati, Your Honor, they have stated a bill, Your Honor, for the pending bills of the petitioner, Your Honor.
I don't understand what you're saying.
So the GE, Your Honor,
you expect me to know all the facts of the case. Who's the GE?
The Garrison Engineering, Your Honor.
So what are you submitting?
In the meantime, Your Honor, Your Lordship, while coming for the consideration, the Garrison Engineering of Mohanbari and Dijan Panitola and one more Nakagi Santogaon Guwahati, Your Honor, Your Lordship, have stated a bill. We are not getting the bill. They have stated a bill, Your Honor. We are not getting the bill that are pending within the Garrison Engineering.
But the Garrison Engineering is Shillong division only.
Yes, in the meantime, Your Honor,
Well, the matter will be resolved. That's my instruction, my lord.
GE from the GE Shillong, Your Honor, circulated the letter to recover the pending bills from all the GEs within the thing, Your Honor. Your Lordship.
Okay, Dr. Mosika submits that the matter is under consideration and is likely to be resolved. So, upon this matter of 3 weeks.
Interim order.
Interim order, when he shall continue
13.
until further orders.
This is also for affidavit.
How much time?
3 weeks' time.
As prayed, 3 weeks for the time allowed.
14.
Your Lordship, here the state respondent has to file their affidavit.
May it please Your Lordship. Your Lordship, I'm praying for time on behalf of the state respondents, Your Lordship, to file the affidavit.
How much time?
3 weeks, Your Lordship.
3 weeks as prayed. 3 weeks time granted to the state respondent to file affidavit.
Obliged, Your Lordship.
Hearing. Item 16.
Your Lordship, in the matters, just, I got the instruction from my client, Your Lordship. She has applied for this copy of the inspection report under RTI and not yet been received. So, request me to take some time, Your Lordship.
What inquiry report?
Because inquiry was conducted by the government and the government has filed some report, but it's not the complete
Where?
report. It is filed by this state. Here, some documents here in 7 March 2023.
It's long time
so
back, Your
it's
Lordship.
long, but
Report.
after that, you see, my client has tried to have obtained this copy of the report. And it
But
is
they
not
filed the report. Where's the report?
It is not the report, Your Lordship. Just
Yes,
reference
7th
given.
March dated long time back, Your Lordship. It was submitted and my learned friend was supposed to file some in repo documents, but till date he could not.
Yes.
My lord, and in the meantime, he is enjoying the
Salary.
Oh, very
There is an
smart.
order. There is an order from this court, Lordship, and I filed the contempt when the managing committee says that we cannot pay the payment because another petition is pending. Then I have filed impleadment and I was impleaded. That contempt I was told. Now what they are doing, Lordship, now they are taking time
And she's a fourth teacher, Your
and
Lordship.
government affidavit is very clear on what are the documents need to be substantiated. Needs to be placed to claim that he or she is as a supported teacher.
Your Lordship, here in this case, after
Start.
So, Your Lordship, give me some time, Your Lordship, to produce this inquiry.
No more production. Inquiry report before this court.
it is not
Submission of detailed report of position of Samiti Jabin Nisa Khatun in Singi Mari girls as AUP.
So,
Yes.
here in this case,
See.
what's the report given? It is nothing to the report. What the report, Your Lordship? This is not clear, Your Lordship.
Yes.
The report, there should be some report. There is only the reference given, some matter, some clarification given by the headmaster. So this is not the report. Independent persons has contacted the report. So his report should be here.
It's not here the report of the SDSU.
Independent persons were.
He's the project director, Your Lordship.
Where's the report, project director?
Report, yes, Your Lordship, it is submitted.
Where? See from here. Where's it?
Project director report is not here.
Yes, I have submitted to them, supplied copy to them also. Wait.
Project director report is not here.
My lord, now can they go against the affidavit filed by the government? Government affidavit is very clear, Lordship.
Let them take out the report from this thing only.
Yes, this one.
No, take it from there. Where's the report? Not yes, this is the one. Show from which page the report.
This is the complete report, type copy also.
No, show the report. No question, type copy, not the report of the headmaster.
14th May.
See if that signed by the headmaster or by the project director.
Ex officio members.
Who?
Yes, sir.
He is one of the respondents.
One of the respondents.
He is a convent, he is the headmaster. His person will be reported.
And entire problem was created by him only.
1 second. See, on 25th of April, the inquiry report time was taken to produce a report on an inquiry conducted by the state respondents. Where is the state respondent report?
Only this one given to me, and I was.
Don't give that excuse that's given to me. You're a counsel. Given to you, you'll produce everything. They'll give you a basket, you'll come and give it here. Please, you're an experienced counsel. Before you produce a report, you have to check what's in the report. What is this bunch of papers? Where's the report of the state? Are his submissions correct? There's no report of a state respondents here.
This is a complete report. Let the matter be, Your Lordship, come up next week.
1 week. Utter confusion. This matter after 1 week for the hearing. Yes. Instructions will be received by the SNMT in the meanwhile.
17.
Yes.
Gratuity matter, we have already paid. They are before this honorable court for interest. We are already in the
6%.
My lord, Lordship has passed in one case.
Now, my lord, 6% now, even bank is not giving 6%.
Even?
Even more than that.
Bank interest?
Yeah, bank interest is less, my lord, now.
So give him fixed deposit interest. How much?
Earlier it was fixed deposit interest 6%, my lord. But Justice Mir has figured it out. Now, my lord, the bank interest is also less, my lord.
I thought it had gone more.
No, my lord.
No, gone.
I thought 7.5% now. No.
No, my lord, not 7.5. It is only PPF, my lord, 7.5 they are giving.
And with regard to the senior citizen lordship, that rate of interest is a bit high.
8.5. 1% more.
If my friend is disputing the rate of interest, that at present the rate of interest is low, then I can place lordship.
Show me the earlier order. How long is the delay?
4 years, lordship.
And what is the amount?
The amount is 13 lakhs, lordship.
13 lakhs?
Yes, lordship. 13 lakhs, 380, lordship.
So 6% simple interest, how much will come now? 4 years delay.
Good amount of money, my lord.
It will be 4 years, 3-4 months. 4 years.
How much will come to? Because as per the act should be simple interest, correct?
The current market rate, lordship.
Yes?
Yes.
Simple interest at the current market rate.
So what's the current market rate?
The current market it will be more than 6%, Lordship, because
In interest in the bank now you get more 6% on savings account.
My lord, that rate of interest was that 6% was given looking into the financial condition of the district council, Lordship.
Now the financial condition is more worse, my lord.
Lordship, there are
And it's for 4 years, my lord, they'll be getting 3 lakhs something.
several
See, the thing is that,
Lordship.
see, Mr. Day, we can't pass orders on compassion. This song you've been singing now for how many years?
Yes, definitely.
That GHDC is in dire financial conditions, about to close tomorrow. You know. So what is the, can you violate statutory
I have no argument
Can
of
they
that,
be?
my lord.
Can they
Only
be?
we are at the mercy of this honorable court, my lord.
They have come here seeking enforcement of the law.
We have given, my lord.
See, enforcement now. The thing is that non-grant interests against statutory provisions.
My lord.
So is there any other way? You just decide the interest amount, you dispose it off. What address? You said bank interest how much now? Who has an idea? What's the bank interest now on savings?
5.2 something, my lord.
How much is it?
So I'll the matter is listed tomorrow. I can place all
Not
the
tomorrow, my
details.
lord. Tomorrow I'll be going out
Because
of
there are various pronouncements given by the Supreme Court, Lordship. The
We
rate
have to
is-
give a certain because 6 scheduled area, and the back you have to give a different interpretation. We won't go by mainland India. We'll go by what's the interest rate savings account. We'll give it that much. Be satisfied with that. How much is the current interest rate? No one keeps money in the bank anymore.
If it is 6%, my lord, then it is around 3 lakhs plus.
No.
For 4 years.
No, what I'm saying is, what is the current interest rate now on savings?
Saving, if I'm not mistaken, is 5.2, my lord.
5.2, not this is savings, Lordship.
That can be done. Let this matter.
Then we'll give 6%.
My lord, coordinate bench of this court also granted 8%, Lordship, because 6% was given taking into consideration of the financial condition of the district council, Lordship.
That's why taking same consideration will go
Lordship,
now.
now that is the minimum rate, Lordship.
My lord, SBI is giving in saving, my lord, 3% at present.
3%?
Yes, my lord. That has been instructed. He has checked.
How can he say that whether the money will be put in the SBI or in
2.7.
the bank, which I'll get?
It's gone lower now
interest,
with
Lordship?
0.3%. Don't ask him anymore. Go lower.
No, he cannot compel that I should deposit my money in the SBI. Had I received the money, Lordship, I would have deposited in a bank where I'll get more interest, Lordship.
He could have deposited in share market also, and the capital would have come zero also, my lord. That possibility was also there.
Okay, we'll dispose it off.
My lord, the rate which is showing, my lord, the rate which is showing, my lord, is 2.7, 2.933, my lord. My lord, I'm just praying, my lord, 6% is too much, my lord, because it will come, my lord. It's not because, my lord, we are just sitting over there, right, my lord. It is because of the financial crunch, my lord.
See, we can't go on statutory provisions. Can you go on statutory provisions? We can't breathe.
Because the law is this, my lord, as a simple interest, my lord.
Simple interest 6%, finish.
Now the bank rate is low, my lord. That time it was 6%, my lord. Now it is not 6%.
Now we can't go below 6% also.
My lord, we are at the mercy of this honorable court, my lord.
Oh, we'll pass
Because till now, my lord, we cannot even pay salary of our staff, my lord. That also has to be taken into consideration, my lord. It's not that, my lord, we are just taking out something, my lord, in the year, my lord, and we are saying. That is the ground reality. Even the officers, they are not getting their salary. The MDCs, they are not getting their salary.
Granted. But the thing is that you can't go against statutory provisions. What can you do? Yes, they're right.
No, I have no argument, my lord. I have no argument.
Yes.
We are only on the mercy of this honorable court, my lord. May not be 6%.
How much did you get? You already got 13 lakhs.
13 lakhs.
So you're ready to go at a low interest rate?
No, Lordship, below. Because in fact, 6% was
The benchmark.
not benchmark, it was granted, it was also law, Lordship. That time 7.5 was the rate of interest for senior citizen, Lordship.
For fixed deposit.
Yes, Lordship. They are the senior citizens, Lordship. And for senior citizens, the rate of interest is a bit high, Lordship. Now, the Supreme Courts have given the minimum 8%, 12%, in some cases 18%, Lordship. And coordinates bench of this honorable court has granted 8%, Lordship.
Which coordinate bench?
That Justice Prakash Vaish, Lordship.
No, now there is a division bench judgment, my lord, which has been made to 6%.
That is why I am not
6%.
I am not claiming for 8, Lordship. Since my
Follow the division bench judgment was there.
Yes, Lordship.
Yes.
Let it be 5%, my lord. That is my
Let
prayer.
it be 6%.
How can he?
Let my prayer be recorded, my lord, please.
Yes. The instant.
So, item number 17 and 18, my lord, common order may be passed.
Where 17, 18? This is 17?
17 is the same, my lord.
18. Where is substance? These two matters being similarly situated, which is regard to the release of gratuity and leave of petitioner are being disposed of by this common judgment and order. Stamp. The petitioners in these petitions, next paragraph. Now, the amount been paid only for the interest, right?
Only for the interest.
Yes, sir.
In petition, in that item number 17, Lordship, I have come only for gratuity, Lordship. So far as the item number 18, I have come for gratuity as well as leave salary. In that case, leave salary has already been paid before coming to the court, Lordship, in item number 17. So
what has been paid? Interest?
Leave salary was paid on the time of the retirement itself. Prior to they approach this
Oh,
honorable.
19, not after it, 19.
Yes. Had been duly sanctioned the gratuity amounts, but still maintain a grievance with regard to the delay in the release of the same, which Learned Council has submitted is a period of over 4 years.
Over 4 years.
It's from the date of when the payment of gratuity was due. Stop. Next paragraph. Mr. S.A. Sheikh submitted that the non-grant of the gratuity in time by the respondents is in violation of the statutory provisions of the Payment of Gratuity Act 1972, and such a right cannot be denied by the respondents. Stop. He therefore prays that interest on the delayed payment of gratuity be awarded by this court at the rate of 6%. Stop. Next paragraph. Mr. S. Day, the counsel for the respondents, has put up the same argument that the respondents are in dire financial straits, straits, and in fact cannot even discharge the burden of paying the salaries of the employees, serving employees regularly. He prays that if any interest be levied, the same be at the current rate of the savings bank, at the current rate of interest yielded by savings bank account in the State Bank of India, which is between
2.7 to 3%.
2.7 to 3%. Stop. Stop. Next paragraph. This court has considered the prayers, prayer and also the submissions of the counsels for the parties. Stop. And notes that the claim for interest is also a statutory right which cannot be denied. Stop. which cannot be denied. And non-awarding of interest will amount to a violation of the statutory provisions. But however, keeping in view the financial health of the respondents, this court, in line with the division bench judgment rendered in writ appeal number 34/2017, which was rendered and ordered in the judgment dated 18/3/2019 in WA 3417, hereby directs the respondents as simple to pay interest to pay simple interest at the rate of 6% per annum from the date the amount of gratuity had become due. Till the date of payment of the same. Stop with the above noted directions. These matters stand closed and disposed of.
I have only one clarification, Lordship. So far as item number 17 is concerned, I am claiming for interest only for gratuity, Lordship. So far as and so far as item number 18,
leave salary and thing.
Yes,
it is further clarified that in WPC number 93/2020, the claim of the petitioners only for interest on gratuity, whereas in WPC number 322 or 2020, it is for gratuity and for leave salary.
19.
We have received the copy of the affidavit, Lordship, that they have filed. Lordship, we need some time to reply to
tomorrow. Tomorrow.
1 week's time maybe, sir. Lordship,
Yes,
we
Mr.
need to reply.
Chanda submits that a corrected copy of this has been received. He plays the matter next week. According to this matter next week on so and so.
Twenty-two. 22.
Yes, sir. So.
Sir, Lordship has fixed the matter today for hearing, my Lord. This other councils are ready. My friend Mr. Paul is appearing for MBSC.
What other hearing matters? Anyone are ready apart from this one?
20. 20. 20.
Yes. I'm ready.
You ready? Because apart from this, I think we won't take up any other hearing matters. 20. What's the matter about? A short matter.
Dispute. No partial dispute.
Where's Mr. D? Is ready? Then we can take it later. Yes. You wait then. Ready matters. You wait. Why?
So next week will be.
Any urgency?
Yes, urgency is there, my lord. They are taking all the
20 after 1 week, yes. On a prayer, Dr. Almozika, then. I don't want to make you wait unnecessarily, yes.
Master. Item number 24, Lordship. Item number 24, Lordship.
Already adjourned, I think.
There was some confusion with regard.
Yeah, 24 years.
The matter can be fixed after.
Who's appeal what I said? You have some urgency, correct? Yes, which is 24.
24. 28. Item number 28.
You have no urgency. You have urgency, you wait. We'll take it up. If no urgency, then no problem.
It can be taken up on another date also.
This is a very small issue. Very small.
Which one?
This what
28. Then you wait. Then they'll call the matter.
My lord, if your lordship permit me, my lord, that matter, my lord, has been substantially delayed. That my lord, check station. On last occasion also, I made a prayer, my lord, if I be permitted to upgrade. So this matter is in the list, my lord.
Then you wait. We'll sit up at 2 years.
My lord, 19, my lord, we are here. My colleague is also.
Yeah, then we'll take it up. We'll take
my
it
lord,
up.
we'll take up
24.
19, my lord. Kamakshi is partner.
Just now.
It was called, my lord, then
I was
affidavit was
outside,
filed.
So my friend, so now we are still here, my lord, the matter can be taken up.
It's only called.
Yes, my lord, I was here. You were not there, my lord.
No, my lord, I just went out to attend a call, my lord. So, however, my lord, we are still here. My friend is also here. We can do the matter.
Yeah, there also.
My lord, I missed out the call supplementary number 1.
Too bad.
19, my lord, hearing 19.
Yes.
This matter can be taken up. In Kamakshi is partner.
Yes.
My lord, item number 19, my lord, can be taken up.
We'll take up the other matter first since you're not here. Yes. All take Ladisha. Now, yes. Number 22. We'll take up 19. Yes. You inform Mr. Paul. Yes. Yes, we'll take up number 22 first.
22.
It's already been called out.
My lord, the issue involved in this case that MPAC has issued the advertisement for appointment of for selection of the social officer in health department. And that health department in the health department.
Social professor?
Social officer. Social officer. Okay. Now in that advertisement, my lord, the requirement is one must have the MSW, preferably 5 years experience. And all the candidates appear. They face the written test as well as the interview. And the private respondent was a figure in the serial number 1. And MPS has recommended for his appointment. Now we are challenging his recommendation on primarily three grounds.
Okay.
He did not fulfill, my lord, 2 criteria mentioned in the advertisement. He did not fulfill both. And number 2, my lord, the admitted fact.
First, he does not fulfill the. Does not.
He did not
He's not
fulfill
eligible.
the,
I mean, not eligible.
Yes, he did not fulfill the.
Is not eligible as per the advertisement.
It was as per the advertisement.
Okay.
My lord. And number 2, my lord, the MPAC has no authority to change the criteria laid down by the appointing authority, the department.
Okay.
These are the my lord, the few
to change criteria given by requiring department.
Yes, by the requisition department.
Okay.
Now may I take your lordship attention to the materials.
What was the third point? First, he's not eligible as per advertisement.
Yes.
Second, you see MPSC has no authority to change the criteria.
Yes.
Given by the requiring department. And number 3?
Yes.
What is the third point?
That is the primary. These are the two.
Why you reduced it to 2 points? He said his senior said 3 points.
These are the 2 points.
2 points.
I club together that criteria. 2 criteria are there.
Yes.
One is the MSW and experience, but we club together, my lord. These are the issue, my lord. Now, may I take lordship attention to the page number 29. The petitioner has finished her, my lord, MSW, specializing in the mental health. My lord. Page number 29.
29,
my lord. I pass out my lord, the MSW. Yes, Annexure 2, my lord. Pass out
qualifications.
Yes, Data Institute of Social Sciences.
Now you say that she has a diploma.
My lord, is it a full course, my lord? Is
on
a
mental health.
MS, yes.
Where is that?
My lord, lordship, kindly see from 3rd semester, my lord, the syllabus are included.
Introduction to mental health.
My lord. Now,
Okay.
if I take a lordship attention, now 3rd semester, now for example, the social sciences and health and development, health and
Yes, I've seen that. Introduction to mental health.
Introduction, my lord, mainly introduction to mental health concepts and interventions, my lord. Community health, and my lord, the 4th semester, legislation, programs, policies in mental health, perspective on mental health, poverty and marginalization, child and adolescent mental health and seminar on emerging mental health issues, my lord. Just the background, my lord. The MSW, my lord. It is like when we go for the graduation, two my courses are there. One is general and one is major. Now in this MSW also, there are two courses. Both of them are considered as MSW, but one student can go for specialization in one particular subjects, and another person can study general papers only, and yet they can all of them can club together as a MSW degree holder. Now, admittedly, this petitioner, she has finished the MSW with specialization of the mental health.
Okay, you see that she's did MSW with major in mental health.
Yes.
But
they
not
call it
indicated.
specialization in mental health.
Specialization, okay.
My lord. She passed out in 2009, my lord. And she has the credits. If lordship kindly see the mark sheets, credit hours. My lord, the credit hours, she has a 12 credit hours, they call it. This is the course they completed, the studies. Now, whereas the private respondent, I will come in his mark sheets, my lord, he has only 3 credits. Because the paper he had studied is only a general paper. Whereas this petitioner, she has finished the major paper, so-called the specialization paper. Therefore, in-depth studies on the mental health, she has done it. Therefore, this is called as a specialization paper. Now, she passed out, and my lord, thereafter, she has the adequate experience, page number 32. After she passed out, she was serving in the Sun Gear also. My lord.
Yes.
Page number 32. And thereafter, my lord, page number 33, there was also advertisement in 2011 for appointment of, my lord, a psychiatrist, social worker. My lord. The qualification it required was, my lord, graduate in psychiatry, social work from any recognized institute. Now, my lord, she also appeared for this, and page number 35, her name was figure number 1, my lord. She was my lord, in figure number 1, and thereafter, my lord, the page number 36, page number 36. Well, there was some mistake in the advertisement, therefore correction was made internally also.
No, just come again to this advertisement. Now this is in MIM hands, right? Director of Health Services invites applications from eligible candidates for bona fide of India also. Qualification. Now you're asking a psychiatric social worker. This is your post. Number 2.
This is another post, my lord. I'm just.
What's the connection between that post and what you're seeking here?
My lord, the post we are seeking here is a higher post than this one.
No, but what
the lower post also I want to highlight, my lord.
That means in this post you were selected.
In this post I face it, I was not selected, but I
in this 34 advertisement you were selected against this post. Right.
My lord, I was selected, but I was not given the appointment. Another person was appointed.
In this advertisement, page 34.
34, my lord.
Psychiatric social worker.
Yes, my
You
lord.
appeared for the interview.
Interview, I was failed. Another person was selected. But here, my lord, I want to show.
Shown as number 1.
My lord.
In 35.
My lord, I was figuring number 1 for interview others, but appointment was not. She was not given the appointment.
Why?
Somebody else was appointed, my lord.
Number 2 was appointed.
Number 2.
Who got 70%?
My lord. Yes, my lord. I annexed this paper to show, my lord, to convince my lord that even the lower post is requires specialization.
No, but why didn't you get the selection if you're number 1 in the select list?
My lord, this is select list, my lord, for my lord.
Change.
My lord, she was not given she did not receive the appointment, my lord.
No, see, for further information, for further instructions, successful candidate at still number 1, number 2, on request to report undersigned on or before 22nd September. Well, she never went.
My lord.
She didn't go for. What happened? I don't understand how then you didn't challenge at that point of time.
My lord, that was not a challenge. That
Why?
was not challenge. That was not challenge, my lord.
You got 76 and the one got 17, the other one got appointed.
My lord, she was not, my lord. She was not received the appointment, my lord. In the final selection, I think she was out.
Higher selection?
Final selection, my lord. Final selection. But now, my lord.
Then what is the purpose of showing this then?
My lord, the purpose of
just to confuse the issue.
My lord, the purpose of showing this material is to show that even this lower post require the education.
We stick to what we stick to we stick to the what we're concerned with, Mr. Chandra.
I'll yes. Well, now, Lordship, can you see page number 37, my, the certificate also, the experience certificates, my dear.
Yes.
Well, and now the advertisement, page number 38, where we are concerned with, madam.
Yes.
This was issued on 8 January 2018. Now, the qualification we mentioned, page number 39, Lordship, can you see the post also mentioned? Social officer, my lord, page number 39. Menham Meghalaya, Shillong, my lord. Now, the qualification, they require a master degree in social work, MSW/PhD, in the field of mental health, preferably with 5 years experience in the field of mental health from recognized institutions.
Yes.
This is the qualification it requires. Now, all were
MSW stroke PhD.
Yes, PhD. Admittedly, me, including the private respondents, we are the MSW, not the PhD. Not the PhD. Okay. Now, see the next page, number 40. After screening, my lord, I received this letter for appearance of the screening test, page number 40. And thereafter, my lord, the notification was out on page number 41. My lord. And thereafter, my lord, we appear, and page number 42, call for personal interview.
How many people appeared? 1, 2, 3, 4, 5, 6. Okay.
My lord.
Yes.
Page number 42. It says that on the basis of the result of the screening test held on 24th February 2021 for recruitment to the post of social officer at such and such, you are hereby required to appear before the such and such for interview. So this was a call for interview. Now, page number 43, my lord, is a experience certificate. There, my lord, I was appointed as a officiating, my lord, social
Same
officer
post.
temporarily.
The same post.
Same post. The post advertised
That
for
was
this.
in 311.
My lord.
You, the prisoner appointed. Yeah.
My lord. Pending filling up the post by the regular candidate recommended by the appropriate authority, subject to discharge, without notice and without assigning any reason thereof, Shrimati Sansach is hereby allowed to officiate temporarily as social officer.
Okay.
Sansach. So I was officiating in the post till today.
Till now also.
Till now also. Till now also. Till now also.
Okay.
Till now also. Now I may come to the page number 45. This is to whom it may concern by my experience in the field of in the institution is it is there. Now may I come to the recommendation, page number 46, notification. Now is this notification, my lord, 22nd. The result of the interview for the post of such and such conducted by the MPSC and such is thereby declared the name of the successful candidates recommended by the commission as follows. Robert Sansach, my lord, he is a private respondent. The recommendation of candidates shall confer no right, my lord. So this was published on, my lord, 22nd December. 22nd December. Now, my lord, after declaration results, there was a, my lord, rumor that the petitioner, the selectee, did not have a requisite qualifications. Therefore, my lord, the inquiry was made, not only others also, candidates, but we put up the representation before the authority, page number 48, my lord. Page 48 is my representation.
Page 48.
48, my lord. On 3rd January, immediately, my lord. During that winter vacation was on, or voice was not regular, but immediately I put up, my lord. Now it says, with reference to subjects cited above, it is reliably learned that the candidate selected in the recently held personal interview for the post of social officer at such, which was conducted on such by the MPSC and result whereof was declared on such, lacked the eligibility criteria for specialization in the field of mental health and work experience of 5 years in the field of such, as mentioned in the advertisement and such. My lord, that one, my lord, everyone has the impression that every candidate has the requisite qualifications. Therefore, all of them face equally. Now, that application was put up, and subsequently, my lord, the page number 49, another, my lord, so-called one NGO had also put up the RTI seeking information, and the reply was given to him 31st January, my lord. And the relevant, my lord, disclosure, page number 51 of the information. qualifications, experience are disclosed, my lord.
Why are you using NGOs?
My lord, we came to know he was
to pressurize the government to cancel the selection.
No, she also applied. I'll come to that part. The petitioner also applied for the RTI.
Then why annexing this one by some NGO?
My lord, this is public, my lord, document. Therefore, it is. She also annexed. Otherwise, she has also her own information. Now, in that, my lord, the paper, page number 51, qualification, my lord, serial number 3 is the private respondent selectee, and writ petition is serial number 6. Now, all of the master of social work. Now, the work experience, my lord, the serial number 3, district social audit resource person, district and such. So he did not have the work experience of mental health. Okay. Whereas, my lord, the petitioner, serial number 6, social officer, Minhams, my lord. She has enough, more than 5 years experience. Then thereafter, my lord, the mark sheet also there, page number 53. The marks also disclosed. Serial number 3, the selectee she secured, total mark, my lord, 186.9, whereas the petitioner secured 178.3. Page number 53.
Where is that?
Page 53, man.
How much the petitioner secured?
Petitioner secured 186.9. Sorry, the selectee. Whereas the petitioner secured 178.3. She was stood in the second position. Second.
So now, fair enough, the selection is done.
My lord. In terms of securing marks, my lord, that is a disclosure. Okay. No one dispute that one. My lord. Page number 54, my lord, the petitioner herself also put up the RTA application in the month of February, seeking information from the MBSC also.
Yes.
And the reply was given page 55, and she came to know, my lord, the internal communication between the requisition department and the MBSC, page number 56. My lord, here everything reveals. She comes to know this. This letter, my lord, written on 22nd February 2016 to the MBSC. May I read, my lord?
Where does she reveals what? That's number 5 draft assessment.
My lord, now draft advertisement is enclosed here for kind action as earliest. Now, the draft advertisement, page number 57. Now it says, my lord, minimum qualification is MSW/PhD in the field of mental health. Okay. Now, number 5, my lord, applicants should have more than 5 years experience in the field of mental health from recognized institutions. Now she came to know in the advertisement, MPSC said only 5 years is the preferable experience only. So the MPSC has changed, and nobody knows this, my lord, including me and other candidates also. They don't know. Only through the RTI it was revealed. Now it indicates, my lord, that the MPSC has changed the selection criteria. This is one of my grievances. I'll come, my lord. Now,
you have any authorities on this?
My lord, I'll with the support of lordship permission, I will supply some judgments to support my contention. Now the page number 58, the mark sheet of the private respondent. He had finished the MSW in Martin Luther University, 2010.
58 is not the one. It's some MS Yohun Dhar.
My lord, 58 lordship is looking page number 19.
Some other name.
Election 19.
What's the name private respondent? Yohun Dhar.
No, I'm sorry, not the private respondent. Stand corrected. But my lord, I have annexed the mark sheets of other candidates to show that, my lord, in 2008.
What relevance will have other candidates? What relevance mark sheets other candidates? What relevance will it have in the context of our case?
In this context, I want to show, my lord, that Martin Luther University did not offer a specialization paper when the private respondent passed out MSW. Therefore, I just want to show this. And
how can you show that? Suppose they didn't offer those topics, for the subjects. I mean, it's Yohun Dhar. Who is she?
Another candidate.
So where's the syllabus? Or where's the prospectus? Where's the course? I show first semester, they offered it, second semester, SW, you don't have mental health. Show from the college, show what, not someone else's mark sheet. Now you can take credits in any branch you want.
With lordship permission, I may skip with this. Yes. But my lord, I want to show the lordship may kindly see. It is admitted fact that, my lord, the Martin Luther University did not offer specialization paper.
Where is
only
that?
for that purpose.
Where is that?
Your lordship may
show
kindly
us
see.
Prospectus. I mean, whatever courses and offer.
True RTA. May I just come with that? For the time being, Lordship,
No,
kindly
from
see
the-
my
you can get the
rejoinder
website.
affidavit. Rejoinder affidavit, my lord, we put up the RTA application before the Martin
let's see.
University, and they have given reply also.
Yes.
Lordship, kindly see my rejoinder affidavit, which we filed on 15 March 2023. My lord, the type copy, my lord, the last page.
Yes.
Page 10, my lord. The last page, my lord. This information we received through RTA.
One second.
My lord.
Where does it say that?
My lord, may I read with lordship permission?
Yes.
Now, we are in receipt of your RTI application that is
Where's your query?
Well,
Where's your query? Where's
well,
RTI application?
Number one, my lordship, kindly see. Information as to when specialization course subject was introduced in this university for students pursuing MSW. Kindly provide copy, supply copy. If any
No, where you
objection-
write about mental health?
My lord, I'll come back.
Where is that? They say that.
Reply, lordship, kindly see. Reply 2014.
Information as to when specialization course subject
Yes.
was in this university for pursuing master social work. Now, where does it say that specialization in mental health is offered or not?
My lord, it is in the reply, may I read with lordship permission? The same page. In 2014, it says, the then Department of Social Work introduced focus papers on public health and family child welfare in 2014. The focus paper was then changed to specialization subjects in 2016 with 12 credits, inclusions and such. In 2018, a more comprehensive syllabus of specialization was introduced, whereby the fieldwork credits, research, dissertation, and enhancement subjects like media, gender, and one online course needs to be taken from outside the university, which has total credits of 39 credits, has also been included as part of the...
Nothing is here. You have given a generic question, you give generic answer also.
My lord. Point number two, my lord. Point number two. Whether students graduating in MSW before the introduction of specialization course subjects are considered to be graduating.
Why you slanted these questions this way?
My lord.
You slanted your questions in a very clever way. Now, where's the question that said that do you offer specialization in mental health or not? To question of Martin Luther. Where's the question? Where's the question in your RTI application?
My lord, this is the RTI application we reflected.
Mr. Chariso, let us see your RTI query, the question you put.
RTI application, my lord.
Yes. You have an excellent rejoinder, I suppose.
It must be,
See, the thing is that if you want to point it, your point is based on a very, is a very narrow compass. Whether the qualifications that the respondent has will make him or her eligible to be selected against that post. Now, your ground is that Martin Luther, from where he got the MSW degree, does not offer specialization in mental health.
Yes.
And as such, if the draft advertisement or it says preferable that mental health should have experience or degree, whatever, that they do not possess it, yes. Now, the thing is that now your questions, what are your questions? Your questions are, when was specialization course reduced? What specialization? Rocket science.
No.
Then?
My lord, specialization course. My lord, specialization course.
This you show the RTI query. Let us see you produce it.
My lord,
in lunchtime you bring it. We'll take it up again at 2 o'clock.
RTI application.
Your query, yes. You produce it.
I'm ready to produce. Definitely,
by 2 o'clock.
It is my duty to produce. I can produce it, my lord.
2 o'clock.
I can produce it.
We'll disregard it. We'll disregard this RTI thing. We'll reconvene.
2 o'clock, my lord, may not be possible. She is still in the service. May I pray, my lord, day after tomorrow?
No. We'll disregard it. We'll have it at 2:15. We can't keep this matter pending now. We just will. By 2 we'll sit again.
We would.
On whatever materials are here.
We would.
Okay, yes.
We would.
mean, is in the private respondent number?
5.
5.
My senior is coming.
Where's the gown? Don't. There's no stay order regarding the appointment, correct? Then?
Still, the department did not report appointment.
Mr. Guru, why there's no stay order? The selection been done?
Lordship is admittedly, Lordship, we are the appointing authority and the selecting authority is the respondent number 4. This should have been done.
They've selected, and given you the list. You're the requiring department, correct?
Lordship. So you have to appoint whoever is being recommended by the respondent.
Yes. But you've not done it, you've sat on it.
Should have been done. Should have been done.
What has happened to Mr. Changreso? Yes, Mr.
He's coming.
Suruh pada siapa you? Baru punya kan. Mudah-mudahan ya. Mudah-mudahan. Mudah-mudahan ya. What's happened to Changreso? He's gone for lunch.
Yes, I think he has some meeting, Lordship. He's coming, Lordship.
Yes,
Some meeting, small meeting, Lordship.
What meeting?
Yes, he's coming, Lordship. We told the Lordship at 2:15, Lordship.
Yes.
I'm so sorry, we got the impression that it is 215. I'm sorry.
Mr. Majao gave you the wrong information.
My lord, the application we have obtained from the party. Well, it says number 1, my lord, information as to when specialization course subject was introduced in this university for students pursuing MSW. Kindly supply copy, if any, of such resolution taken. Whether students graduating of MSW before the introduction of the specialization course subject are considered to be graduating in general social work. So the RTI basically, my lord, information is seeking general information.
What is specialized courses available as well?
Yes, whether specialization course is available or not. Okay. And the reply, my lord, that affidavit, I just draw your lordship attention once more. In that additional affidavit, rejoinder, my lord. There, my lord, the reply number 2, reply number 1, may I read, my lord? It says, in 2014, the then Department of Social Work introduced focus paper on public health and family child welfare in 2014. The focus paper was then changed to specialization subjects in 2016 with 12 credits. In 2018, a more comprehensive syllabus of specialization was introduced, whereby the fieldwork credits research as a dissertation and enhancement subjects like media, gender, and online course needs to be taken from outside the university, which total credits of 30 credits has been included as part of the specialization credits. Whether students graduating in MSW before the introduction of specialization course, that reply is, my lord, yes. Such students are considered to be graduating in generic.
What's this BOS minutes?
My lord.
What is BOS minutes? BOS minutes? BOS minutes of 2016. No, what, regard to mental health, any specific query and any specific answer?
My lord, admitting that specific pinpointed query was not made. But generally, my lord, this question was put up, and they say that prior to 2014, there was no such
advertisement says specialization.
Yes.
What does it say? Advertisement again, Mr. Chandrasekhar?
My lord, specialization says in the field of mental health. And
specialization in mental health.
Specialization in the field of mental health. Mental health. Now the university replied that those who finish before introduction of specialization, they are considered as a generic students, like a general course in the graduations. The RTA. Now when we come back to the, my lord, the writ petition, lordship, the advertisement, lordship, can you see again, page number 39. Page number 39. My lord, it says that degree in social work, PhD in the field of mental health. My lord.
5 years experience.
5 years preferable, my lord. Therefore, they are downplaying the criteria. They mentioned preferable. Therefore, it becomes, my lord, the criteria is, according to me, is changed by the MPSC. Now, according to me, these issues are here. In the field of mental health, is, my lord, is admittedly a specialization course. And number 2 is, my lord, 5 years is a mandatory criteria. Now, we come through this RDI, and being agreed, my lord, we have filed, and the respondent has also filed the affidavit. May I take lordship attention to the affidavit filed by state first, my lord. Because the state is the, my lord, authority. Department is authority, my lord. What criteria is required for the post? They are the authority to decide. My lord, page para 8 of the affidavit is very clear. Para 8.
Of the state.
Of the state.
That is respondent number
1 to 3.
1 to 3. Worship, can you see para 8? Worship, me, allow me to read.
1 second. Our Guru. Yes.
Madam, with regard to the amendments made in para 12 of the writ petition, the state responded back to state that this directorate by letters and such forwarded a draft advertisements indicating that the qualification for the post of social officer is master in social work with specialization in mental health. So according to state also, though it is not mentioned specialization, it is a specialization criteria. And that page number 14 of the state affidavit also, they have reiterated this position.
So just as seen the draft has been applicant should have more than 5 years experience in the field of mental health.
Yes.
Yes.
Now, therefore, my contention is that when the authority laid down the criteria and forwarded to the selection authority is bound to follow that one. In the event, my lord, if there is no criteria later on by the requisition authorities, then, my lord, the law is very clear, as lordship is aware, that the selection authority can formulate its own policy reasonably. But admittedly, in this case, my lord, the department has laid down the basic criteria. Now, candidates as well as the selection authority is bound to follow that one. Now, in my case, this is change. This is the, my lord, reply of the state affidavit. Now, the MPSC, my lord, before I go to the judgment, MPSC affidavits, what you kindly see, MPSC is respondent number 4, my lord.
Number 4.
My lord. Para 10 of the MPSC affidavit. Para 10, my lord. Para 10.
What number 4?
Respondent number
1. Yes, okay. Yes.
They have taken this plea, my lord, in para 10. With regard to the amendments made in para 19 and 20 of the writ petition, the answering respondent states that the candidate recommended by the commission, respondent number 5, does not lack the eligibility criteria. As with the advertisement dated 2018, the qualification for the post of social officer is that of master degree in MSW, PhD in the field of mental health. Therefore, a candidate possessing either master degree in social work or PhD in the field of mental health can apply for the said post, but not as to what has been portrayed in the petition, stating that a candidate who possesses master degree in social work should also have mental health as specialization course. And the respondent number 5 had completed the degree course and also had mental health as one of the subjects in the degree course. It is further stated, as for the experience mentioned in the said advertisement, it is preferably of 5 years, my lord, and thus it is not necessary that the recommended candidate should have an experience of 5 years. So this is a plea taken by them, my lord. According to me, my lord, the plea taken by them is contrary to the requirement of the service. May I just come to the annexures?
What was copy of cumulative transcript? What is this? Annexure 7.
My lord.
Annexure 7. What is Annexure 7?
Annexure 7, my lord. This is, my lord, this is the syllabus of the university, the Martin Luther University. And their lordship kindly see page number 24, Annexure 7 of the MPSC affidavit.
Yes.
My lord, this subject, my lord, it is in the middle, my lord. Special work in the field of mental health. They have mentioned at the bottom, my lord. This is included in the 4th semester. Page number 24, my lord. Field work.
Social work in the field of mental health, yes.
My lord. Special work in the field of mental health. Credit is 3 credits. Now, this is one of the subject only, one of the paper. Therefore, this is considered as a general studies. Whereas in the case of the petitioners are specialized subjects. Now, this is, MPA also relied on this. This is enough. According to MPSC, this is enough. Now, the page number 25, where they have annexed the paper of the university also. A student, the extracurricular activities he has involved in my lord, workshop on mental health, human resources in Meghalaya and Northeast India conducted by Martin University. It's a practical work. But this subject is confined to a specific area. Therefore, they admitted in the RTI that this is only a generic studies, not a specialization.
Not Nehu, another MCLU. Yes. You said Nehu just now. The Martin Luther
paper. Martin Luther University paper. And now, my lord, page 26, where the MPSC has taken further plea. is that, my lord, they said they have received this short communication from the director. The information they sought is, my lord, with reference to your letters and such, I am directed to request you to kindly furnish this office with the service rules OM before the commission can take up the necessary action on the matter. So they sought for this information. And the department has given this reply. It says, my lord, with reference to the subject on your letter cited above, I am to inform you that there is no service rule or office memorandum with regard to the post of social officer at Menham. My lord, they are taking this plea, and they say there is one draft OM was given. The next page, page number 28 and 29.
Okay.
And they do admit it, my lord, it is mentioned preferably 5 years. It is mentioned. But it is clear, very clear, my lord, page number 28. But qualification. Lordship may pain to see one more thing. He or she must pass, my lord. Qualification, point number 2.
Is the memorandum was ever issued?
It was never issued. But perhaps they are relying on this, ignoring the communication given by the department. And that affidavit, my lord, with regard to this, matches the admission on the part of the MPSC also. The para, my lord, relevant parameters of the lordship. They do admit that, my lord, that
yes.
Well, para 15, my lord, 14, 15. Para 14 and 16. MPSC acknowledged that, my lord, this OM was never published, never acted upon. But perhaps they are acting upon this. So my humble submission is that the MPSC cannot rely on the OM which is never published, my lord. Now, my lord,
There's 14, nothing in 14 about OM.
I'm sorry, I'm still corrected, my lord. Para 13, my lord. Para 13 of the affidavit, MPSC affidavit. May I read, my lord? With regard to the averment made in para 23 of the writ petition, the answering respondent states that there was a communication from the commission to the concerned department requesting to furnish the service rules or OM as to enable the commission to take up necessary action. However, the state respondent replied to the state communication stating that there is no service rule or OM for the post of social officer, and at the same time a draft memorandum undated was attached, wherein the qualification for the said post was mentioned as the same as that of the advertisement. So they are acting on the unpublished OM, my lord. My humble submission, my lord, they are supposed to follow with the instruction, specific instruction given by the department, that is a draft advertisement. Now this is the reply. Now the last affidavit filed by the private respondent, my lord, para 9, 14 and 18 may take a lordship attention.
Para
9, my lord. First lordship, para 9. May take lordship. With regard to the statement made in averment made in para 19, 20 and 22 of the writ petition, the deponent denies the same. The deponent states that on having the requisite educational qualification, that is MSW as required in the advertisement, and having secured the highest marks of such marks in the selection process, as such, the deponent was rightly selected on the merits and recommended for appointment to the post of such. Shillong. May I come to the para 13 to save lordship time? With regard to the averment made in para 26A and 2 of the writ petition, the deponent denies the same. The deponent states that as per the advertisements and such, the eligibility criteria for appointment to the post of social officer is that of MSW PhD in the field of mental health, preferably 5 years experience in the field of mental health from recognized institution. As such, in terms of its advertisement, the minimum eligibility criteria is either MSW or PhD in the field of mental health. As related above, the deponent has the requisite qualification MSW as required in the advertisement. It is also humbly submitted that the petitioner has misconstrued the eligibility criteria in the advertisements and such, and moreover, the petition does not possess a MSW in mental health. So he said that I'm not having that the mental health though MSW, the Commission did not say that one. In the last paragraph, may I refer to, my Lord, para 20, para 18, para 19, my Lord. With regard to 5 years experience, he replied in this way, my Lord. With regard to statements made in para 26 and 27 of the writ petition, the deponent denies the same and state that the deponent possesses the requisite educational qualification of MSW as required under the advertisement and also secured the highest marks and such. So with regard to experience, he did not reply. He did not reply because he did not immediately have the experience.
So no reply to the 5 years?
Yes, 5 years. He was silent with regard to 5 years. Because on record, he doesn't have that experience. Now, the issue involved in this case, number one, is who is the authority to lay down the selection criteria?
No, you say that the MPSC had no authority to change the criteria even by the requiring department. That's one of the point of argument. Second one is that that the respondent number 5 was not eligible as per the advertisement. That's the two grounds. And specialization, that's a ground that you have developed in your own case, saying that especially if the MCLU or MLCU does not offer specialization in mental health, that means there could not have been any possibility of the writ petitioner ever gaining experience in the field of mental health. Whereas you have attended and undertaken course specifically doing with different aspects of mental health. Right. And then coming with that, he says, so 5 years experience, he has not been able to show, plus no specialization course offered by Martin Luther, so he's unqualified for the post. Okay. Yes, now?
Whether it is in the
I'm just trying to collate your argument, yes.
The judgment may not.
Yes. Because see, one thing, we walk a very fine line. Now, fine line is that once it comes to a commission selection, now the grounds of interference are, unless you allege, there's a lot of malafide or certain things.
Well,
yes.
Lordship is very, very correct. The law is, general law is, my Lord, once
now you have taken part in the selection, now you can't turn around and challenge it after coming out successful.
My Lord, that is the general law. And the Supreme Court said there is an exception.
No, there are exceptions, of course. There are exceptions everywhere, but then you have to at least satisfy the court that this is an exceptional case where undue favor has been shown to the respondent number 5.
Right.
What judgment do you have?
My Lord, the first judgment, my Lord, may I place, is, my Lord, in the field of mental health, it says, I say it is a specialization. And the MPSC, as well as the private respondent, say that it is not specialization. Now, these contesting views, my Lord, who is the right authority to lay down the criteria? Now, regarding to this, my Lord, one of the apex court judgment, may I please, my Lord, para 9, my Lord.
Citation.
The citation. Para 9, may I just read out? The first respondent completed the MPA degree program from Maharsit and University Rohtak. The mark sheets which have been relied upon by the first respondent indicates that during the course of the second semester, he studied human resource management as a subject. In the fourth semester, the first respondent had a course in industrial relations and labor legislation. Studying these two subjects would not lead to the conclusion that the first respondent holds a postgraduate degree or diploma in the disciplines which have been specifically spelled out in the advertisement or in any allied subjects. The MPA degree cannot be regarded as allied to the postgraduate degree or diploma in social work, labor welfare, industrial legislation, or personnel management. The recruitment was being made to the service of the applicant. The advertisement did not specifically provide how equivalent has to be established between a postgraduate degree or diploma in the subject specified in the advertisement and a postgraduate degree diploma in the allied subject. The applicant as an employer has best suited to judge whether the degree of the first respondent was in an allied subject. Unless this assessment was perverse or contrary to the requirements prescribed, the tribunal had no reason to interfere. We are of the view that the tribunal was manifest in error in holding that the first respondent was qualified merely because he studied two subjects as a part of his MPA degree program, namely such, my Lord. So my reference to this judgment, my Lord, my humble submission is that it is a health department that is the best authority to judge which qualification is required. And according to me, the affidavit is very clear that it is a specialization course. And if we go by this, my lord, admittedly, private respondent never advanced argument that he is a specialization degree he has. It is not his case. He said the MPA, the MSW is enough, my lord. Therefore, the criteria laid down by the department is binding to all of us, including the
Now, yes, but the department about the advertisement. Now, first come to the judgment where you see that the commission doesn't have the power to, to change the requirement given by the requiring department. Let's come to that first before we come to this.
I'll come to that.
You come in sequential order. Yes. Come to that first one. Come to stick the advertisement first. Then next you come to the point of eligibility.
With regard to advertisement,
yes.
May I cite 2006 Volume 9 SEC, page 507, my lord.
2006 volume?
My lord, volume 9, my lord. 2006 Volume 9 SEC, page number 507, relevant para, my lord, 21. My lord, in this background also, my lord, there was the selection authority has misinterpreted the rules, and with regard to the age factor, my lord, there was a confusion. Advertisement, they mentioned one, and the rules provide otherwise. Therefore, Supreme Court says that, my lord, that merely the criteria mentioned in the advertisement in contrary to the rules.
No.
Para
21 he said.
Para 21, may I read?
One second.
May I read? The present controversy has arisen as the advertisement issued by the PAC stated that the candidates who are within the age of 2001 and 2002 shall be treated within age for the examination. Undoubtedly, the excluded candidates were of eligible age as per the advertisement, but the recruitment to the service can only be made in accordance with the rules, and the error, if any, in the advertisement cannot override the rules and create a right in favor of the candidates, if otherwise not eligible according to the rules. The relaxation of age can be granted only if permissible under the rules and not on the basis of the advertisement. If the interpretation of the rules by PAC when it is issued the advertisement was erroneous, no right can accrue on the basis thereof.
Not applicable. Come to that point, we think the requiring department says this, and the PSC has given A and they put up B. That we have to be clear. This is nothing. This is just that the PSC they ignored the rules. Rules are there; they have to be followed. To the set rules. Now you can't issue an advertisement. Deholds the rules on violation of the rules.
Madam, here also the reason I cite here.
Yes.
That they are saying that they are relying on the advertisement. Advertisement never says specialization. Number one. Number two, advertisement never says that 5 years mandatory. Therefore, my contention,
but they never ask specialization, even in the draft advertisement.
Therefore, my lord, it is not mentioned specialization.
Why are you making a case specialization?
My lord, therefore, the nature of the work. Therefore, the beginning of my argument, I was cited the lower post. Then this social officer, even lower post requires specialization because after all this dealing with a special group of people in the hospital, my lord. Therefore, this requires specialized treatment to integrate those mentally suffer people to integrate in the societies, special counselings, my lord, interaction with them. This requires specialized help. Therefore, it is mentioned. Therefore, it requires specialization. Now, the reason I cited this one is they are trying to derive some power from the advertisement. That since the advertisement did not spell out 5 years mandatory, or for another issue is that specialization, there is nothing wrong in our selection.
Yes, okay.
My contention is that the advertisement did not specially mention specialization, even not mention 5 years mandatory. That do not confer any rights upon any candidates, because that as of now, admittedly, the rule is not there. In the absence of the rules, executive instructions govern the field. Lordship is aware. Now, as of now, the instruction given by the director to the MPSC, my lord, attaching the draft advertisement, that governs the field. That governs the field. Therefore, any selection made in contrary to that criteria mentioned in the draft advertisement, my lord, one cannot derive any strain.
Okay, any other authority which says that?
My lord, that is one judgment. My lord, I I will come to that one, but before that, my lord, the 2007 volume 8 SCC, my lord, page number 100. Because the case of the respondent is that once I participate in the selection, I cannot turn around and challenge. My lord, this with regard to exception, may I just take to para 21, para 20, my lord. Para 1819, my lord, refer to the general law that once a candidate appear, he or she cannot turn around and challenge. But para 20, in short, may I refer, my lord? Yes. We, however, not oblivious that there are certain exceptions to the aforementioned rules, but we are not concerned here with in the present case. My lord, citing this, my lord, there is a general exception. Now, second decision may I rely is, my lord, the 2008 volume 4 ACC, my lord, page number 619, relevant para, my lord, 59 and 61. Well, 51 and 61, 59 and 61.
Sadananda, hello.
My lord.
Para?
My
lord.
Para 59, 60 and 61. Okay. May read, my lord. Yes. It is also well set a position that unsuccessful candidates cannot turn back and assail the selection process. There are, of course, the exception carved out by this court to this general rule. This position was reiterated by this court in the latest judgment in Union of India and such, where one of us as a party. There was a case where different cut-off marks were fixed for the unreserved candidates and the scheduled castes and scheduled tribes candidates. This court in Para 10 of its judgment endorsed the action and recorded a finding that there was a power in the employer to fix the cut-off marks, which power was neither denied or disputed, and further that the cut-off marks were fixed on a rational basis, and therefore no exception could be taken. The court also referred to the judgment in Om Prakash and such, where it has been specifically that a candidate appears in the examination without protest or subsequently is found not to be successful in the examination, the question of entertaining the petition challenging such examination would not arise. The court further made observation in Para and such matter. May come, madam. Para 20. Para 60, madam. Para 60.
61 or 60?
Madam, to save lordship time, may come to 61. Madam. The learned judge, relying upon the decision of Sons and such, seems to have found an exception to this rule and has more particularly relied on the observation made in Sons and such. But in this case, the government has committed glaring illegalities in the procedure to get the candidates for examination under 1955 rules. So also in the method of selection and exercise of the power in taking out from the purview of the board, and also conduct of selection in accordance with the rules. Therefore, the principle of estoppel by conduct or coercion has no application to the facts in this case. Thus, we consider that the procedure offered under such rules adopted by the government or the committee, as well as the action taken by the government, are not incorrect in law. My lord, and further, my lord, we do not think that there is a case opposite for the present controversy. In the reported decision, the court found a clear-cut breach of the 1955 rules. It also found that the names, though were required to be called from the employment exchange, were not so called. The court also found fault with the procedure involved. We are afraid such is not the case in the present case. No deviation from the rules, it's important, my lord, no deviation from the rules or no inherent defect in the selection process would render the whole selection illegal, as either been alleged or proved. No deviation, my lord. My humble submission, my lord, in the absence of the rule, instruction is there, and therefore NPSC has deviated from the instructions. So this is one of the exceptions, my lord. My lordship can may consider. Another judgment
rules anyway.
My lord, 1997, volume 9 ACC. Page number, my lord, 527. Well, para may I come straight away to para 16, my lord.
Yet another circumstance.
My lord, yet another circumstance is the government had not taken the pause from the purview of the board, but after the examination were conducted under the 1955 rules and after results were announced, it exercised the power under the proviso to Parasansad of 1970 notification, and the pause were taken out from the purview thereof. Thereafter, the selection committee was constituted for the selection of the candidates. The entire procedure is also obviously illegal. It is true, as contended by States and such, that this court in such case and other decision referred herein held that a candidate having taken a chance to appear in an interview and having remained unsuccessful cannot turn around and challenge either the constitution of the selection board or the method of selection as being illegal. He is stopped to question the correctness of the selection. But in his case, the government have committed glaring illegalities in the procedure to get the candidates for examination under the 1955 rules. So also the method of selection and exercise of power in taking out from the purview of the board and also conduct of the selection in accordance with the rules. Therefore, the principle of estoppel by conduct or acquiescence has no application to the facts in this case. Thus, we consider that the procedure offered under such rules adopted by the government or the committee as well as the action taken by the government are not correct in law. Now, my lord, I'm citing this, my lord, with the contention that the deviation, my lord, cannot be the ground for me. Deviation is taken place. Now, candidate is not prevented to assail that action, my lord, to assail that action. That one also, my lord, selection was done already. In the midst of selection, my lord, those division taken place and the candidates challenge that one.
Mid selection is different, yes. Next one.
Now, another decision, my lord, may I come to another point. The respondent is, my lord, emphasizing that the conduct, once participated, we cannot take. My humble submission is that exception is there. It is not my case that, my lord, we saw the deviation. Situation would be, my lord, different if the candidates are aware of the nature of the requirement. My lord, in the midst of the selection, they come to know. Then if I don't challenge it, then the principle of estoppel may come into play, my lord. But the situation is different. None of us, including the private respondent and me, are aware the internal communication between the MBSC and the health department. My lord. Therefore,
no, you already shown the answers because of office memorandum. That is why following that draft office memorandum, they issued advertisement. The preferably is come from there.
My lord. But now, admittedly, if the
department becomes optional.
But no, my lord, my respect submission would be, if the department communicates to the MBSC, that is a draft OM, then they can follow that one. But the department has made it very clear that since it is not published, therefore they have formulated the draft advertisement also, mentioning the criteria. Therefore, the OM is yet to see the light of the day. Therefore, nobody can rely. Therefore, since it is not published, even director did not rely on it. If the government is acting on that, director would be definitely follow that one.
Now, what judgment is this?
This judgment, my lord, may I say, refer, para 17. With regard to estoppel, my lord, I am referring to this point. Para 17 in the, my lord, the ending part of that paragraph. In law equally, lordship, you see, the last part, my lord. In law equally, the tribunal ought to realize that there can be no estoppel against law. If the law requires that something be done in a particular manner, it must be done in that manner. And if not done in that manner.
Read para 17.
My lord.
Read para 17.
Para 17, my lord. And the ending part, the lordship mechanism is the ending part. The second line from the top. In law equally, my lord. In law equally.
Okay.
Lordship.
Oh, for last page.
My lord, same lordship.
Yes. In law equally to an order can be the sole law. Yes.
My lord. Therefore, something that is illegal cannot convert itself into something legal by the act of the third person. So my citation is limited. That, my lord, if the selection is done against, in contrary to the rules or the instructions, my lord, estoppel doesn't, my lord, come into play. Otherwise, the illegal action convert into legal action. Well, and another judgment, may I please? This is the last judgment, may I please, madam? Here in this case also, my lord, the party has taken the ground that once you participated, you cannot turn around and challenge it. Here the apex court held, my lord, the selection criteria was changed. Here also, my lord, the selection authority has changed the marking system. May I come to, my lord, para 20? Para 20 first, my lord. 20. I have flagged it, my lord. But it is para 20.
Yes.
It is a pertinent question.
The Board of Examiners.
Yes. The Board of Examiners on their own changed the criteria and made it purely merit-based by introducing an interview and also preparing the merit list on the basis of marks awarding a type test, written test and interview. As per the provision of such and such manual, type test was not mandatory. Anybody who would fail in the type test could be promoted subject to the writer that they would have to qualify the typing test within 2 years from his joining. What we notice is that the division bench approved the reasoning of the learned single bench judge. The relevant extraction of the judge of the single division bench is reproduced herein. Learned single judge, as already noted above, has rightly proceeded to observe that interview was not at all subscribed by the provisions holding the field. We are also of the same view that procedure prescribed ought to have been adhered to by the Board of Examiners. Board of Examiners on their own could not have changed the procedure already holding the field as laid down by the Executive Council. However, the division bench fell in error in applying the principle of estoppel that the appellants having appeared in the interview and being unsuccessful proceeded to challenge the same on the ground alone allowed the appeal set aside the judgment of the learned single judge. The division bench, having approved the reasoning of the learned single judge, ought not to have interfered in the judgment of the learned single judge on a technical plea. The division bench ought to have considered that the appellants were class 4 employees working from sunset onwards and expecting them to have raised serious objection or protest at the stage of interview, and understanding the principle of changing the rules of the game was too far-fetched, unstable, and unwarranted. The case laws relied by the division bench would have no application in the fields of the present case, as none of the judgment relied upon by the division bench laid down that the principle of estoppel would be above law. It is settled principle that principle of estoppel cannot override the law. The manual duly approved by the Executive Council will prevail over any principle of estoppel or equations. The division bench relied upon the judgment, may come to the 25. The judgment relied by division bench. In the case of such, my lord, the plea taken by the unsuccessful candidates was that the marks prescribed for interview and confidential reports were disproportionately high, and the authorities could not fix a minimum to be segregated either interview or in the assessment annual confidential reports. In the above case, there was no violation of any statutory rules or the eligibility determined by the rules-making authority. My lord, in the case of Uttar University, the objection taken by the unsuccessful candidates was with regard to the composition of the selection committee. This again would not have any application to the facts of the present case. In the case of Chandra Tiwari, the unsuccessful candidate did not find the result of the interview palatable, and the objection taken was that the process of interview was unfair. This also has no application to the facts of the present case. In the case of A.K. Mani, the unsuccessful candidates were given equal opportunity and no violation of any statutory rule was alleged. As such, this judgment also have no application. In the case of Madan Lal, again, the objection taken by the unsuccessful candidate was regarding the process of interview being unfair. This case also not have any application to the facts of the present case. On the contrary, what we find is this. In the case of Dr. Sansaj, my lord, it has been held that the suitability criteria is to be laid down by the rule-making authority, and the selection criteria cannot be laid down by the selection board or selection committee unless specifically authorized. In the present case, firstly, there was no authorization to the Board of Examiners to lay down the selection criteria, and further, there was no clear violation of the suitability criteria laid down by the rule-making authority. Paragraph such and such, my lord. I may skip that one and come to, my lord, para 20, my lord, para 31. Para 31. para 31. Further, in the case of Tata Chemicals versus Commission of Customs, well, it has been laid down that there can be no estoppel against the law. If the law requires something, well, I prefer that one. Well. The last one, para 32 and 33. Well. It says, for the reasons recorded above, the appeals deserve to be allowed. They are accordingly allowed. The impugned judgment of the division bench is set aside, and judgment of the single bench that it is restored. Here, my humble submission is the apex court also, the selection authority has no power to alter the selection criteria. Well, admittedly, in my case also, the MPSA has altered it. Well, the mandatory criteria is reduced to a preferable. Number one, there is a 5 years experience. They lack jurisdiction. Number two, the essential criteria of education, the education qualification, specialization. It is a department has made it.
You see, that means that what was required was diluted by the commission. That's all.
Yes. Well,
dilution of criteria.
Well,
okay.
And that dilution do not confer any rights to any candidates, including the private.
And dilution will not confer any rights.
Yes. Well,
okay.
Well, he cannot hold victory arising from this dilution.
Yes, finished.
My lord, this is my humble submission.
Mr. Gurung. Yes.
So far, the grounds taken by they are challenging the action of the respondent number 4. So I think it will be appropriate if respondent number 4 will react to that.
Where's number 4?
Mr. Paul is on the screen.
Yes. Yes, Mr. Paul. Now you heard arguments. You've heard arguments. The challenge is that you had no right to change the criteria.
I would most respectfully beg to disagree on this.
Yes.
Your Lordship should have seen, that what had been forwarded to the Public Service Commission was only a draft advertisement.
Yes. Yes.
And
Yes.
there has been reference to an office memorandum minutes which I, with my learned friend, had taken your Lordships to.
Yes. Yes.
Well, this is at page 28 of my counter affidavit. Initially, there was exchange of certain letters between the department and the Public Service Commission where we had also sought a clarification as to what are the rules. So we were informed that there were no rules available, and thereafter this office memorandum came into being. And if your Lordships can see qualification at serial number 2
Page?
It's page 28.
Yes.
This says, the qualification is she must pass Masters in Social Work, PhD in the field of mental health, preferably with 5 years experience in the field of mental health from a recognized institution. So there's no question of dilution per se,
Yes.
Because the dates would be very relevant if your Lordship see this office memorandum, even though it is undated, it shows that it is of the year 2017.
Yes.
And the advertisement, which is at page 39, it starts from page 38 of the writ petition at next 8. This is of 8 January 2018.
Yes. Yes.
So, my humble submission is that there is no question of dilution, We had sought clarifications. Once the clarifications were obtained, on the basis of that, the advertisement was made.
Okay. Clarifications given, was memorandum given by them to you? It's OM?
Yes, that's what we're saying, It is of the Directorate of Health Services. If your Lordships can see page 28 again. It is an office memorandum of the Directorate of Health Services.
Yes, okay. Right.
Now, that having been said, even though my learned friend has sought to distinguish between estoppel and when that will not apply. Now, essentially, these facts regarding the fact that what they now urge was a mandatory qualification, and they say we had relaxed it by making it preferable. This fact was very much to her knowledge at the time of the advertisement, when she participated in in the selection process.
But his argument is that the draft advertisement requires is, that specifically, but then dilution happened
My
in
lords, your lordships, as your lordships have rightly pointed out, my lords, it is only a draft advertisement.
Yes.
A draft advertisement, my lords, cannot lay down the rules for a certain game to be played. It is a draft. It is not final.
Yes. Yes.
Had there been specific instructions, well, it's that this is the advertisement that is required to be published, and this is the necessary qualifications that is there, well, I would have been on a sticky wicket. But what they are relying on is a draft advertisement. A draft advertisement, well, cannot confer any rights on any party.
Yes.
And assuming, well, what he's saying is correct.
Yes.
Well, when the advertisement was made.
Yes.
And what they say, well, it's that from it being a mandatory qualification to it being made preferable, it was very much within the knowledge of the petitioner. At that stage, Malad, she never chose to come before the Honorable Court and challenge it. She took her chances, and after having failed, Malad, in that, she now comes and challenges it, saying that it has been diluted by us.
Yes.
So, Malad, my humble submission would be that the judgments which have been referred by my learned friend would not be of any assistance to the petitioner.
Yes.
Other thing is, well, it's that in the process of selection, what has basically transpired is, well, it's that the respondent number 5 is more meritorious than the present petitioner. That position is not disputed even by the petitioner herself.
Yes.
So, well, insofar as the Public Service Commission is concerned, well, we have taken a very neutral view to the entire matter. We published the advertisement, well, on the basis of whatever materials was available before us. We have recommended the most eligible candidate to the department.
Yes. Anything else?
That's all, Melons. Very limited purpose for me to address your lordships on this subject.
Okay. Yes, who's next? What about state? What do you have to say about officer memorandum? Is this but this was never issued formally?
My reply is very clear that we don't have any rules. So this memorandum has not been published.
But was this given by you to the PSC?
It appears so from the affidavit of the MPSC.
Okay. Yes.
Page 28, 27 and 28.
Clarification was sought by PSC. Huh? Yes.
Please, Lordship, I'll request Lordship to look at the advertisement once again, my Lord.
That is in the
that will also find in my affidavit, your Lordship, text up of respondent number 5.
Yes.
Page 12, my Lord. The first row itself, my Lord. Social officer at Mimhans, Meghalaya, Shillong. Pay skill so and so. Master's degree in social work, MSW.
Stroke PhD in the
field of mental health, preferably with 5 years experience in the field of mental health from recognized institution. Additional qualifications is not relevant for the present purpose, my Lord. My Lord, the word specialization is not mentioned anywhere, my Lord.
Yes. This is the course noted also.
My Lord, specialization in my humble submission will have a different connotation, my Lord.
Yes.
Now, if Lordship kindly sees the certificate of the petitioner, my Lord, that is at page 31 of the writ petition, my Lord. This says, my Lord, 31.
Yes.
Simple degree, my lord, Master of Arts in Social Work.
Yes.
Nowhere it mentions that she specializes in mental health, my lord. Same is with my degree, my lord.
Yes.
Page 15 of my counter affidavit, my lord.
Page
15 of the affidavit.
Yes.
Mr. Robert Benjamin Dhar has been awarded the degree of Master of Social Work. So, my lord, in my humble submission, it is not necessary for your lordship to lift the veil now what lies behind the certificate, my lord.
So you want to go by the baseline only?
Because in my humble submission, and even if you go, even if your lordship want to lift the veil, my lord,
yes,
at page 14, my lord, is
Page?
the transcript of the affidavit itself.
Yes, cumulative transcript of courses.
My lord, the courses I have undergone, my lord, in my Masters of Social Work. In the first semester, lordship will see MSW 505, Dynamics of Human Behavior.
Yes.
In third semester, Medical Social Work.
Yes.
That will involve mental health, my lord. And in fourth semester, Social Work in the field of mental health. 613, my lord, MSW 613.
That's serious.
My lord, now if you come back to the writ petitioner's transcript, my lord.
Writ petition.
In the writ petition, my lord. My lord, first semester understanding
Which
society.
page?
Page 29 of the writ petition.
Yes.
My lord, first semester there is nothing with regard to mental health at all, my lord. Second semester also I couldn't find anything connected with mental health, my lord. Even third semester there is hardly anything except one introduction to mental health concepts and interventions.
Yes. That's specific to mental health anyway, yes.
My lord, that's third, and in fourth there are 2-3 courses is done in the mental health, my lord.
Yes.
Now, my lord, I've indicated at least 3 courses which somehow touch upon mental health, my lord. Maybe she has done one extra paper, but this is not a specialization, my lord, anywhere to indicate that this is any kind of a specialization in mental health.
Hmm. Yes.
Now, this is an admitted position, my lord. At page 53, the I scored 186.9 marks, my lord. The scorecard, my lord, at page 53.
Yes.
My lord, serial number 3 is my name, my lord. It's not reflected, but serial number 3 is mine, my lord. 186.9 marks.
She came second.
And C is at serial number 6, my lord.
Yes.
C gets 178.3. No, my lord, it's a matter of fact that I scored much more than the petitioner, my lord. Now,
can that be negated?
Now the question comes, my lord.
Yes.
The preference that has to be given to 5 years of work experience. It has been alleged that I don't have any experience. I have annexed document to indicate that I have 5 years experience, my lord. Even if it was not there, my lord, the preference, what is the meaning of what preference, my lord? Your lordship have dealt with the matter. Preference will come into picture only
similarly situated candidates.
If other things are equal, my lord. Yes. If both scored the same marks, my lord, then somebody with 5 years experience will be given a preference in appointment, my lord. Here's a case that marks, I am far ahead of her in the marks, my lord. So the preference clause will not come into picture, my lord.
Yes.
In that regard, I can place 2 or 3 Supreme Court decisions, my lord. flag A, my lord, para 7.
Yes.
Para 7, my lord. Admittedly, in the advertisement which was published calling for applications for the candidates for the post of dental officer, it was clearly stipulated that the minimum qualification for the post is BDS. It was also stipulated that preference should be given for higher dental qualification. There is also no dispute that MDS is a higher qualification than the minimum qualifications required for the post of respondent. I was having that degree. Respondent 1 was having that degree. The question then arises is whether a person holding a MDS qualification is entitled to be selected and appointed as of right by virtue of the aforesaid advertisement conferring preference for higher qualification. The answer to the aforesaid question must be in the negative. When an advertisement stipulates a particular qualification as the minimum qualification for the post and further stipulates that preference should be given for higher qualification, the only meaning it conveys is that some additional weightage has to be given to the higher qualified candidates, but by no stretch of imagination it can be construed to mean that a higher qualified person automatically is entitled to be selected and appointed. In adjudging the suitability of a person for the post, the expert body like Public Service Commission, in the absence of any statutory criteria, has the discretion of evolving its mode of evaluation of merit and selection of the candidate. The competence and merit of a candidate is adjudged not on the basis of qualification he possesses, but also taking into account the other necessary factors like career of the candidate throughout his educational curriculum, experience in any field in which the selection is going to be held, his general aptitude for the job to be ascertained in course of interview, extracurricular activities like sports and other allied subjects, personality of the candidate as assessed in the interview, and all other germane factors which the expert body evolves for assessing the suitability of the candidate for the post for which the selection is going to be held. In this view of the matter, the High Court in our considered opinions were wholly in error and so on and so on. Second reason, my lord, flag B, para 10, 11 and 12. So basically, reiteration of the same principle, my lord, that the preference will come into picture only when other things are equal. The third judgment, my lord, para 13 and 14.
Well, it's directed Anita Puri case only.
Yes, my lord.
Yes.
Should I read, my lord, the other?
Anything
No,
else?
so in my humble submission, the preference, the point that is argued by them is without any substance, my lord, in view of the settled legal position. Now challenging the advertisement, my lord.
Come to that point, regarding this, only one part on the court regard to the, like Mr. Paul has argued that draft advertisement anyway, that requiring that is the changing the advertisement. That's what you think.
My lord, on that, my lord, my submission will be, my lord.
Yes.
The rule of estoppel, my lord, when it applies and when it will not apply, my lord.
Okay. Yes.
My lord, there are definitely exceptions to the rule of estoppel, my lord. But when those rules of estoppel will apply, the cases cited by my friends, when the rules of the game are changed after the rule has begun, my lord, in those cases, estoppel will not apply, my lord. The case where interview marks were increased after the advertisement, my lord, or interview marks were reduced, the changing the rules of the game, that is the case when a rule of
No, his case is based on the foundation that mental health was a requirement. Correct?
My lord, what I'm trying to submit, my lord. So once he participated in the advertisement.
Okay, that angle. Okay.
What I'm trying to submit, my lord, in this case, estoppel will apply, my lord.
Okay.
Because estoppel will not apply. Examples can be the rules of the game are changed after the advertisement has been issued, my lord, or after the closing date of advertisement, or it happens like a Kripax case, my lord, famous case, my lord, that interview board member was related to one of the candidate, my lord. So these things were not in the knowledge of the applicant, my petitioner at that point of time. He comes to know only after he participates in the process, my lord.
Now in this case, rules will apply because
in this case the advertisement is very much there, my lord.
Yes.
After taking her chance, my lord.
Yes.
It is not that the advertisement was changed afterwards, my lord.
Yes.
My lord, here a distinction can also be made between challenging the advertisement and challenging the recruitment process, my lord.
1 second. Challenging the, yes.
Advertisement itself, my lord, and challenging the recruitment process.
Yes.
The recruitment process can still be challenged, my lord, as I submitted, changing the rules of the game after game is begun. So those are matters pertaining to the recruitment process, my lord. But qualificational criteria which are laid down in the advertisement, these cannot be challenged after participating, my lord. The extreme case that, if possible at all, my lord, will be if there are any statutory rules to that effect, my lord. One or two cases, Supreme Court has said that if there are statutory rules, maybe in that case, but even in those cases, in my humble submission, my lord, there should have been a challenge to the advertisement itself.
That has gone beyond the rules.
But here, there are no rules, my lord, is an admitted position. Government is, in the affidavit has clearly said, no rules. So in my humble submission, the rule of estoppel will clearly apply, my lord. The petitioner was very much in the knowledge that these are the advertisement qualifications laid down in the advertisement. They cannot challenge it later on, especially after participating, taking a chance after being successful.
Okay.
So to conclude, my lord, the preference criteria, there is no merit in the case of the petitioner, my lord. Secondly, they cannot challenge the advertisement on the ground that office memorandum said something different, which is not even a case, my lord. At Mr.
Office memorandum said the preferably.
Preferably,
Doesn't say yes, mandatory, yes.
Secondly, my lord, and number 3, my lord, we both are masters MSW, my lord. There is no, it is not a case that she has any kind of specialization. Maybe 1 or 2 papers that she has done extra, my lord, but I have also done. And that is for the expert MPSC to determine, my lord, whether I fulfill the criteria or not.
Yes. Any reply?
Only short reply, my lord. Short reply to my friend Mr. Paul, MPSC, my lord. We just go to page number 22 of the MPSC affidavit.
1 second. Page?
Page number 22 of the MPSC affidavit. Because my friends say that it is only a draft. I see the content, my lord. Page number 22.
Page 22.
My lord. This letter was written on 22nd March 2016.
Number 4, right?
Yeah.
What is the first one?
Respondent.
Yes. Yes.
My lord, the draft advertisement is inclusive with for necessary action at earliest. But it is not that the draft and you do whatever you like. It is not that one. It's very clear. The rule is not there. OM is not there. Therefore, this is a draft one. We formulated. Contents are there. Take actions. Take actions. My lord. That is the.
That's the reply to MPSC.
Exactly.
What do you say?
Yes. So this is binding to the MPSC.
That is binding.
Binding to the MPSC. There is no scope for the MPSC to evolve another criteria. And the letter referred by my friend, the page number 27. Page number 27 of the same affidavit. It is very clear, my lord. The director has said very clear that, my lord, I will inform you that there is no service rule or office memorandum. If, my lord, the office memorandum is required to be acted upon, regardless of the draft advertisement, department could have spelled it out that follow this OM. it is not there. It says that there is no OM, there is no rule. Therefore, in that meaning, thereby, the earlier communication containing the draft advertisement is binding to the NPSC. Now, second...
Now, coming back, yes, why didn't you challenge the advertisement that when it was floated?
My lord, I'm not challenging this advertisement.
Yes.
Everyone came to know after the examination was over. My lord, the requirement of the requirement formulated by the department came to light after the examination.
So it means there's no estoppel against you challenging the advertisement at this stage.
My lord, fact would be, for example, if I'm aware that the internal communication is required this criteria, and I slip over and I took chance, and subsequently I challenge, then absolutely I have no case. I have no case. But none of the parties, including the petitioner respondent, are aware of this internal communication containing the criteria. Therefore, there is no question of estoppel. Now, with regard to my friend, Dr. Muzika, he has referred to the credit system, the syllabus of the two mark sheets. Now, it depends on my lord, the credit system. My lord. May I refer to that one, para 7 of my rejoinder to his affidavit. Para 7 of my rejoinder, reply to the affidavit filed by respondent number 5.
1 second.
Para 7 of my rejoinder, my lord.
Where rejoinder?
Para 7 of my rejoinder.
Number 5?
Yes. In reply to the affidavit filed by respondent number 5.
Yes.
Para 7, my lord. With regard to amendment made in para 7 to 14, the answering deponent denied the correctness of the same, and further beg to submit that the social work in the field of mental health included in the syllabus of the MLCU Shillong for 3 credits in the academic year 2012 as one of the topic out of many in the 4th semester studied by the private respondent number 5 is only a generic or general studies and not concentrated or specialized course. As stated in the
argument is not whole. There's no requirement specialized course. There's no baseline is the same. Only the only thing that troubles the court is whether the advertisement issued was in line with what the requiring department wanted. That's the only thing.
Yep.
That's the only thing that's troubling the court. That if it is found that advertisement was floated, has what they call gone away from the the requirement that is there, considering that for a mental health institute, whether that would vitiate the entire process.
My lord, Roshi pointed out, 2 are mentioned in the advertisement. One is the...
See, this court really is not about the specialization or your qualification. The baseline will be the same, but whether the advertisement given, the draft advertisement, the final advertisement, and the second letter saying that there's no office marijuana operating, so the MPSC could have gone on that basis also there are no rules. Now, what capacity has MPSC, on what basis or what satisfaction have they crafted advertisement in such a way, preferably? But preferably, as Dr. Merzi has submitted, gives a total different dimensions. When candidates equally situated, then preferably, suppose you both score 10 marks each, then preferably given to the candidate who has some more experience, rather than that to say that because you got 5 years experience, you'll be automatically you'll get some some marks. That's not the case.
Correct. Dr. Muzika is right to the extent.
So that's right, but the only thing that troubles the court, even your specialization, whatever, is nowhere mentioned. Like you're trying to make out a case that you have to specialize in mental health. That's not the case. The court will not also accept that. Only thing is that what is the status of the advertisement, whether the rule estoppel will apply or will not apply. In the case that you say that I have not challenged advertisement at that point of time because I'm not aware what the requiring department wanted. And when you found out that the requiring department had mandatorily required that 5 years experience in mental health be there, that should have been introduced in advertisement, was not there, that is why you turned on and challenged it. Not questioning of challenge selection process, but challenging the route itself. That's the only thing.
May I just come in for a second, please?
Yes, of course.
If your lordships kindly have page 25 of the writ petition, I think this entire discussion of the query that has fallen from your lordships would be put to rest.
25.
So what is the prayer of the writ petitioner before your lordships, in this writ petition? I had missed it in the first round, my apologies, I should have assisted your lordships on this.
Yes.
Millards may kindly see the prayer, Millards. First prayer is to set aside and quash the impugned notification dated 22/12/2021 containing the recommendation issued in favor by the respondent MPSC. My recommendation recommending respondent number 5. Second prayer is, Millards, to direct respondent MPSC to make fresh recommendation in favor of the writ petitioner within reasonable time, preferably 1 month, as per the existing merit list, as the writ petitioner secured top position in the merit list. That's number 2, Millards. Number 3, to direct the respondent state authority to consider and offer appointment to the writ petitioner against the post of social officer within a reasonable time, preferably 1 month, after the recommendation made by the MPSC. So the petitioner, Millards, is not aggrieved by the advertisement.
No, I don't understand this number 2.
Number
Number two, prayer, I don't understand.
I'm sorry, Millards.
Number 2, prayer, I don't understand. To direct respondent.
Number 2 prayer is ill-founded, Millards, because admittedly writ petitioner is at serial number 2. She's not at serial number 1.
How does she secure top position?
But what I'm more importantly submitting before your lordships is,
yes,
Millards, the writ petitioner is not aggrieved by the advertisement. Whether, Millards, I have changed it from mandatory to preferable, Millards, that is not even being questioned by the writ petitioner before your lordships.
Yes.
What she wants is, Millards, on the basis of the same advertisement, she should be recommended. In other words, Millards, your lordships, what the petitioner is asking is your lordships to read down the advertisement even without challenging the advertisement. So once that happens, Millards, I don't think the case of the writ petitioner has any legs to stand on, because she is claiming relief on the basis of the very same advertisement.
Thing is, a point.
What has been argued? What has been argued at length before your lordships, Millards, whether I have diluted it, not diluted it, is irrelevant, because she is claiming relief under the same advertisement.
Yes, Mr. Chairman, I don't understand second prayer. 1 month as existing merit list as writ petitioner to get top position. How can he get top position when he came second?
My lord.
On what basis do you found your prayer? This one.
My lord.
Have you founded your prayer?
First
Number
prayer
2.
you set aside his recommendation.
No.
If that is sustainable, my lord. Sustainable, the natural corollary fallout would be to select the person who is in serial number 2. My lord, that is, my lord,
That means that you are not agree with advertisement.
No, my lord. Therefore, this one, it is not required to challenge the advertisement.
No. Then you are contradicting yourself.
But here
we can't have legal fiction and paradoxical legal fiction.
No. Here, my lord, the prayer is, we came to know this criteria after selection was over.
Fine. Even then, your prayer is not there. You should have set aside a quash impugned notification. Why set aside quash impugned notification? That means you quash the entire selection process.
My lord, here the recommendation is.
No. That means then why appoint you? Number 2, if you quash the entire selection process, suppose it's called quash the entire selection process. Fine, have you sought for quashing the entire selection process?
My lord.
On the basis of this faulty advertisement?
No, my lord, even assuming that, my lord, my second prayer is...
It is the court feeling that we didn't look at the prayer first. The hearing would have gone for so long. I mean, going to advertisement and draft requirement and memorandum and rules. There's no question.
My lord,
even lordships have spent considerable time on this matter. This page 25 would have settled the matter in within 5 minutes.
But he may have a point with that. My lord, my response is, my lord, even a lordship assumed, consider that it doesn't require to direct the authority to consider my case. Set aside it, my lord, because the respondent cannot hold a public office arising from this selection process. Now the requirement is very clear. So one cannot be appointed without essential qualifications. And normally, my lord,
now where pleadings have you made regarding advertisement in your petition?
Advertisement?
Against assailing advertisement?
Well, may come to.
Yes, okay. Page 23, para 23.
But just a lot to bear with me. Annexure. But para
23
para
only.
12, my lord.
23, para 23.
Para 12 also, my lord. Para
But you have not carried that on to your prayer.
Where is the para 12?
You can't have both the worlds. You can't say you challenge your advertisement and seek appointment from the same advertisement for which your selection process was held. That's impermissible.
Lordship, where is the para 12 first?
Para says now you're saying that the advertisement is wrong. That's the argument, and that troubled this court also, because on the basis of like whether it had the competence to change the criteria, because the persons holding the exams and the requiring department usually knows what is required. Now you're not challenging advertisement at all.
But we're not challenging that advertisement.
Then why arguing and challenging advertisement? That means that thing goes under the bridge. It's over. The only thing is that now what remains for challenge?
But the recommendation.
What remains? Okay, you take away that advertisement part. We have to take it. Advertisement is above board. Correct. Now you scored lesser marks. You've taken part in the selection process. So what other arguments would you have?
My Lord, humble submission is the private respondent was selected without qualification. Once his selection is in the file, then the second option, my Lord, the Lordship allow
now,
me.
See, questioning a selection process of public service committee is very, very limited.
My Lord, that is there.
It only has to be patently, like it is like stares you in the face. There has been clear favoritism. There's somebody in the board. All those things are there.
Those are there. But admittedly, my Lord, the respondent did not fulfill the criteria. Once my Lord consider that he is not qualified, then
this court is not a technical board to sit over the expert's opinion. Time and time again, we have held that the court sitting in 226 or sitting in every discretionary jurisdiction also, we are not an expert body to sit and judge the merits and the qualifications of candidates, which has been found fit by an expert body. Can we sit and appeal to an expert body's opinion? You cannot.
Then cannot be. Therefore, the competent authority.
That means where would the case be? You're not challenging advertisement. That's the only place. Maybe you had some, you had some.
Therefore, my Lord,
some weapon in your hand. That weapon you never use it. You threw it away and you sought.
Therefore, my Lord,
we pass orders then.
Therefore, my last submission is, my Lord. Last submission is, admittedly, my Lord, this is my prayer. If Lordship consider, otherwise, my Lord, if Lordship set aside the notification which I am seeking, my Lord, result would be fresh selection process would be there. Selection process would be there.
You don't agree with advertisement, the whole basis goes up, Mr. Changreso.
But okay, it is not required to challenge. It is not required to challenge. If the advertisement is agreed with me,
not only that, Phillips, the petitioner wants appointment under that advertisement, Phillips.
Exactly.
One thing is not challenging the advertisement, one thing is wanting appointment under that advertisement.
Yes. Yes, we'll pass order.
Right.
90.
Third party judgment reserved.
90.
Item number 19, my lord, I had prayed for 1 week's time. My lord. They have filed an affidavit, my lord. That is detailed, my lord. Detailed affidavit. So
when is that filed? When is supplied to you?
on 18/7.
Supplied 18/7.
Lordship, just read the order sheets in both item 19 and 24. The petitioners have been taking time for almost a year now on one account or the other. These matters are otherwise we've raised an objection of maintainability.
Day after tomorrow, be prepared. Day after tomorrow. Today is Tuesday, Thursday. Thursday, Mr. You're having some video problems. There's some technical problems. Mr. Sahai, there's some technical problems with the feed.
I'll rectify it.
Day after tomorrow, we'll have those matters.
24.
24 and this one. 24 and this one, day after tomorrow.
Yes, grateful, Lordship.
Cannot hear you also. Yes.
27.
Absolutely.
Wait, please, Your Lordship.
My lord, I'll take this abuse. You see, there is a great sense of urgency. I understand, my lord.
What urgency?
Lordship has
The
a long
whole
day.
carpet's been pulled out from under your feet.
Oh, my lord. Lordship has a long day. I understand, my lord, in the courtroom. But the thing is, this matter is urgent, my lord. Right from the beginning, I am pressing for it. I don't know if we can start, Your Lordship.
But the thing is that, Mr. Sen, what relief can we look at now?
Yes,
the whole thing has changed. The whole dimension has changed.
Exactly, my lord. His lordship, normally lordship query, my lord, is tandem matter, civil court jurisdiction. Now, what jurisdiction the writ court has? I am ready, my lord. I will satisfy on this point. Well, I need to satisfy your lordship. So I am prepared, your lordship. Lordship permits, I can start now.
No, we'll do it some other day.
Then lordship, only thing I will pray, my lord, lordship will give me a short date. Day after tomorrow, lordship might have fixed some other matter.
No, the afternoon we'll have it now. It's the
Friday, I don't know, your lordship.
No, Friday we'll have it on 7th.
7th?
Monday.
This coming Monday, no?
Yes.
The only thing, may I pray, your lordship, because there are many other matters. For me, there is a great sense of urgency. If it can be listed on the top, your lordship.
Mr. Sen, the only thing is that, you see, we are prepared to pass even orders, but the thing is that the whole dimension has changed. Now, whether your writ petition will suffice, will suffice to address the
No, lordship. If I am cannot satisfy, lordship will throw it out, my lord. That is, I will satisfy, my lord. I am prepared on that.
Okay.
But only thing, can it be listed on the top, my lord?
That's up to the court master. He's the master of the roles.
Yes, my lord. You can list it on the top. Yes. All right. Oh, my lord, this is a very small issue. This, I think, your lordship can decide. This is the only thing is, my lord, the petitioner case was considered for promotion, but it was kept under seal cover because on that day, 2 criminal cases were pending. Charge sheet and facing trial. I have annexed the notification.
Yes, Mr. Pandey.
We cannot open it now.
Lordship, I joined the NEHU as associate professor in the year 2013, Lordship. I fulfill all the criteria for promotion for the post of professor in the year 2016.
Yes.
Although DPC should have been carried out in the year 2016 itself, there are many DOPT orders and UGC notification also with that regard, which I'll come to later on, Lordship. But DPC was, in my case, along with other 100 candidates, were held only in the year 2022, Lordship. There was a 6-year gap. Now, subsequently, Lordship, I became eligible in the year 2016, subsequently in the year 2018.
Oh, Professor.
Professor, Lordship. In 2018, a complaint was filed against me. Pursuant to that, criminal proceedings are pending against me, Lordship. Now, the point here, Lordship, is whether sealed cover procedure can be taken in cases where the candidate has been eligible before filing of the complaint, Lordship. I think, Lordship, if I may, Lordship, this DOPT order, which is being relied by the respondents to keep my case in DOPT sealed cover, is annexed at page number 10 in my petition, Lordship. This DOPT order. Page 10. Sorry, page 39, annexed at 10, Lordship.
Yes.
Lordship, para 2. At the time of consideration of the cases of government servants for promotion, details of government servants in the consideration zone for promotion falling under the following categories should be specifically brought to the notice of the Departmental Promotion Committee, Lordship. Number 1 is government servants under suspension, government servants in respect of whom a charge sheet has been issued and disciplinary proceedings are pending, and government servants in respect whom prosecution for criminal charges pending, Lordship. Now, Lordship, my humble understanding, Lordship, is that when a serving employee, a charge against a serving employee is framed, a complaint is drawn, subsequently he or she becomes eligible for a promotion, Lordship. Then immediately,
come again.
When a serving employee, a charge is brought against a serving employee, Lordship, and subsequently to the complaint file or charge is framed, he or she becomes eligible for promotion, Lordship. Then along with others, then DPC is convened, Lordship. When is the DPC convened? As soon as any employee is eligible for promotion, then DPC is convened, Lordship. then DPC makes a list of the candidates which are to be recommended, and if there is a charge or criminal proceeding pending against a particular candidate, then his or her case is kept in sealed copy, Lordship. My contention is that this is not the case with my regard, Lordship, because I have already been eligible for promotion, and subsequent to that, charges have been framed against me, Lordship.
Eligibility and selection process are two different things.
Lordship.
Yes.
Lordship, the department university has relied on this order, DOPT order, to keep my case under sealed copy, Lordship. But there are other DOPT orders, Lordship, which they have disregarded, Lordship. If Lordship allows, I'll take your Lordship with those orders, Lordship. Yeah.
You're not given them by. You give a copy to the other side also.
Yes. Page number 2, Lordship. May I read, Lordship?
Yes.
Timely and office memorandum, it is issued by DOPT, Lordship, the same agency, Lordship. Office memorandum dated 23rd April 2015. Office memorandum. Subject: timely and advance action in convening of Departmental Promotion Committee meeting in terms of model calendar regarding, Lordship. The undersigned is directed to state that with a view of having the approved select panels for promotion ready in advance in a time-bound manner, this department has issued a model calendar for DPC White OM number so and so dated 8th September 1998 as modified by so and so dated 28th January 2015. An indicative pattern has been provided in the model calendar for various events involved in the pre/post DPC related actions. All the ministries/departments have been impressed upon from time to time by this department to adhere to the prescribed timeline so as to ensure that panel is ready in time and is utilized as and when the vacancies arise during the course of the vacancy year. Appointments Committee of Cabinet has viewed it seriously that DPCs are not being convened in time. Delay in promotion affects the manpower planning.
So what relevance does it have?
Lordship, the department has applied DOPT order which goes against me, Lordship.
No, what relevance does OM have?
These orders say.
Just speaks for urgency of having DPCs as well.
Lordship,
it's prevalent in all departments across the board in every corner of the country.
Lordship.
Next, what is there?
Lordship, another order, Lordship. This is annexed at page 4, Lordship.
Same thing.
Lordship. Yeah. Para 2. It has been brought to the notice that many promotion posts are lying vacant.
These are general OMs, Mr. Pandey issued in every department, state department, central ministry, all the ministries this thing.
Lordship.
That is, yes. Anything else?
Yeah. Lordship, then
you've been disregarded forwarding timely DPC. Your case stands a different footing altogether. Your considerations under process, and because of the charge sheet, they've kept the seal cover, correct?
Lordship, yes. Lordship, for consideration of my promotion, Lordship, the selection panel must have the relevant period for consideration, Lordship, for promotion to the post of promotion.
You want to say that because your consideration came before your charge sheet, so they should not look at the charge sheet and consider promotion on the date you become eligible?
This charge sheet will be relevant, Lordship.
Okay.
For my further promotion, Lordship.
But not for your present promotion.
Earlier promotion, because the relevant period is between 2013 and 2016, Lordship.
That time you are eligible for professor.
Yes, Lordship. I fulfill all the criteria.
Post, Vice Chancellor.
Lordship.
Next consideration be Vice Chancellor.
Next, Lordship, in due course of time, I don't know, Lordship. But in that case, Lordship, my humble submission is that this charge sheet and this criminal proceedings will be relevant, Lordship. This will be relevant, Lordship. And Lordship, and as of now, Lordship, the interview selection results have been published, Lordship, and most of the candidates have been given promotion from retrospective date. Some of them is
you'll be given also once seal covers open.
Lordship, yes, but Lordship, the criminal process will take some time, Lordship. My humble submission is that my case is a very limited case, Lordship. This relevant period between 2013 and 2016, I had no complaint against me, Lordship. If DPC had been convened on time, Lordship, then I would be promoted to the post of professor, and I would be facing these charges as a full-fledged professor, Lordship.
Okay. That is your grievance.
That is my grievance, Lordship. But
unfortunately, because the deep is not held in time, so you fell in this trap.
Lordship. Let me present my case from a different perspective, Lordship. Let's say, Lordship, if the DPCs were held on time, Lordship, and then I was promoted to the post subsequent to me becoming eligible in the year 2016, Lordship, then I would be Professor, Lordship. 2 years down the line, a complaint was done against me, Lordship, and charge sheet was framed. Lordship, would I be demoted on the strength of this charge sheet, Lordship? Demoted to the earlier post, Lordship? My humble submission is no, Lordship. Similar is the...
But the thing is that, Mr. Pandey, you have to face reality in the sense that it was not held, and you're not holding the post at that point of time. But that's the only thing that goes against you. See, you can't have that analogy that, if suppose I was promoted, and then this thing's happened.
Lordship.
There's no question of reversion. But the thing is that now, your case, you have to look at where you stand.
Lordship.
For no fault of yours, DP is not held. Now, because of the DP being held, these subsequent charges coming against you,
Lordship.
now you're suffering, it's like double suffering. Firstly, because of the criminal trial you have to face, secondly, being deprived promotion. That is your grievance.
Almost a case of jobless party, Lordship. Yes. Lordship, one more thing, Lordship. Almost all the candidates have been given promotion from retrospective effect, Lordship, and some is far back as 2011, Lordship. On the basis of the selection...
What stage is the criminal trial now?
Lordship, charge sheet has been framed. I think evidence is going on, Lordship, now.
Was charges under 406?
406 of PC Act, Lordship. A lot of sections are there. I'm not, honestly...
Who's doing the case? You're doing the matter?
No, I'm not doing Lordship, that matter. Now, this matter will prolong, Lordship. This is the criminal court. And
when is he due for retirement? What is his age now?
I think I'm 45, Lordship.
45?
Lordship.
They retire 65, right, the professor?
If I at all become a professor, Lordship, my humble case is that let the steel cover be open, Lordship. It may also happen that I'm not been selected, Lordship. Then I have no case, Lordship. This is a perpetual state of suspense, Lordship. I don't know whether I've been, because then I have to try to become eligible for promotion, Lordship. If I have not been selected in this case, Lordship, I have to publish extra papers.
Given set of circumstances, whether... Yes, Mr. Sen, what do you have to say?
Yes, my lord. The fact is this, your lordship comes to my affidavit at paragraph 3, my lord. I have clarified. Paragraph 7, my lord, page 3. Now, the DPC admittedly held, my lord, on 7/3/2022. Now, what was the situation on 7/3/2022, my lord? He was facing criminal trial in 2 cases. Now, I have annexed those sanctions letter at page, my lord, 10 onwards. Both the sanction orders I have enclosed. Now, my lord, the law office memorandum issued by the central government, which the university is following, very clear and very categorical, which I have also annexed. Now, it categorically say what is the situation on the date of DPC, not when he became eligible. That is irrelevant. Now, what my learned friend is trying to convey, that almost 4 years back he became eligible to be considered for promotion. For some reason, DPC was not held, so he cannot apply. That is wrong. Now, the office memorandum categorically say, my lord, on the date of DPC, if an incumbent is facing trial, my lord, his case may be considered, but it will be kept under...
Where does it say that? At paragraph 2?
Yes.
Case where seal cover shall be applicable. Okay.
Yes.
Yes.
The departmental promotion committee shall assess the suitability of the government servant coming within the purview of the circumstances mentioned above, along with other eligible candidates, without taking into consideration the disciplinary case, criminal prosecution pending. The assessment of the discipline, including...
Where are you reading?
My lord, at page 16.
Yes.
Lordship.
2.
Yes, my lord. 2. At the time of consideration of the case of the government servant, the promotion, details of the government servants in the consideration zone for promotion falling under the following categories should be specifically brought to the notice of the government servant under suspension, government servant in respect of whom charge sheet has been issued and the disciplinary proceedings are pending, and the government servant in respect of whom prosecution or criminal charge is pending. Now, 2.1. The departmental promotion committee shall assess the suitability of the government servant coming within the purview of circumstances mentioned above, along with other eligible candidates, without taking into consideration the disciplinary case, criminal prosecution pending. The assessment of the disciplinary process, including unfit for promotion and grading awarded by it will be kept under seal cover. So, my lord, it is very clear and categorical. And further, my lord, this will clinch the issue. This is my view, what I understand. Janaki Raman, this is the famous case on this. This is the Janaki Raman is the famous case at para 6, my lord. I have clarified. I have submitted a list of books, my lord. That is, my lord, AR 1991, Supreme Court, 2010. There is a 3 judges bench judgment, my lord. At para 6. This is, my lord, the relevant page will be 2015. Para 6. Little long paragraph. Para 6, my lord. Page 2015.
Very short para. Para 6.
Para 6, my lord.
Being judged by whom?
Long paragraph.
2015, he said.
Roshi. It's a long paragraph, my lord. Para 6. Sorry. I'm sorry, man.
That is para 4.
You see.
Start from 2. Para 4.
My lord, I'm just.
With
Well,
para
it's 6 only, my lord. 6 is little long. Little long, sorry.
Oh, yes, 6.
Little long. Let's read it, it won't take much time. 6. On the first question, as to when, for the purpose of seal cover procedure, the disciplinary criminal proceeding can be said to have commenced. The full bench of the tribunal has held it is only when the charge memo in disciplinary proceedings or the charge sheet in the criminal prosecution is issued to the employee that it can be said that the departmental criminal proceeding is initiated against the employee. The seal covered procedure is to be resorted to only after the charge memo charge sheet is issued. The pendency of preliminary investigation prior to the stage will not be sufficient to enable the authorities to adopt seal cover procedure. We are in agreement with the tribunal on this point. The contention advanced by the learned counsel for the appellant authorities is when there are serious allegations and it takes time to collect necessary evidence to prepare and issue charge memo charge sheet, it would not be in the interest of the purity of administration to reward the employee with promotion, increment, etc. does not impress us. The acceptance of this contention would result in injustice to the employees in many cases, as has been experienced so far. The preliminary investigation take an inordinate delay and particular. Now, my lord, 2 parts. First part, they are saying when it can be resorted to. Once charge sheet has been issued. Preliminary investigation, that has been urged before the Supreme Court, that's it, that is too harsh. You cannot wait for the preliminary investigation and you cannot deny the promotion. Charge sheet has been framed. Now, that is very clear and categorical, my lord. And exactly, my lord, I have stated, my lord, on the date of DPC, he is also not denying, my lord. He was facing charge sheet, the prosecution, my lord, approval was there, charges were framed and he was facing trial. And this trial is going on even now, my lord. Now, how could he have ignored, my lord, this position of law? We could not have ignored, my lord. It is immaterial what hardship it cost to.
Anything else, Mr. Pandit?
Lordship, this is a very unique, my case is a very unique situation in the sense that this order could not have envisaged a situation where there is this delay of more than 5 or 6 years after a person becomes eligible and the charge sheet is filed. Lordship.
We can't turn back the clock.
Lordship. This
no matter how much you sympathize with your case, Lordship, that you would have been promoted, you would have enjoyed a higher PA, and even if suspended or maybe in you should have enjoyed that both.
Lordship, one last Lordship, if you can, Lordship, can see UGC order, Lordship, which is annexed page 41, Lordship, of my petition, Lordship. Subsequent pages is 46, Lordship.
Yes.
Lordship, para 6.3.1, Lordship.
Page
46, Lordship, para 6.3.1.
6.3.1.
Lordship. May I read, Lordship?
Yes.
6.3.1, or teacher who is, this is UGC regulation, published in Gazette of India, Lordship. A teacher who wishes to be considered for promotion under CAS, Career Advancement Scheme, may submit in writing to the university/college with 3 months in advance of the due date that he/she fulfills all qualifications under CAS and submit to the university/college the performance-based appraisal system pro forma as evolved by the concerned university, duly supported by all credentials as per the API guidelines set out in these regulations. In order to avoid delays in holding selection committee meetings in various positions, screening selection, various positions under CAS, the university college should immediately initiate the process of screening/selection and shall complete the process within 6 months from the date of application, Lordship. And in my case, I have submitted my application 5 months prior to me becoming eligible, Lordship. University have not complied with UGC, which is the governing body of university, Lordship.
Okay. That's it.
Lordship, that's it, Lordship.
We'll pass orders.
The fact is this, my lord, the DPC was held on 2022. And the date of DPC, my lord, these things were there. No, my lord could not have ignored the settled position of law. And my lord, my learned friend, my lord, he's saying he became due for promotion 4 years back. It was never done. He never came before this. He could have come at that point of time before this court. He never came.
Lordship,
So that cannot be a consideration, my lord, to waive the requirement of law laid down in the office memorandum and settled by the Supreme Court.
It's an admitted fact. But it was admitted fact by the university that I became eligible in 2016, Lordship. In the affidavit,
I'm not saying all those things, my lord. My only issue is here, my lord, whether we could have opened it. We could not have opened it, my lord. We have kept it under seal cover. He should appreciate one thing, my lord, that we have considered his case, and it is under seal cover. It's not that we have not considered him at all.
I'm being victimized unnecessarily, Lordship, because I don't know whether I'm eligible for professor or not. If I know what are the contents of seal cover, I may have failed, Lordship. Selection committee may have found me unfit, Lordship. In that case, I'll publish more journals. I'll take part in.
You can do that now,
Lordship. So, Lordship, at least it is, Lordship. Last, Lordship, if Lordship allows, in my petition, Lordship, I've annexed just for persuasive values, Lordship. I've annexed one judgment of Allahabad High Court. Ranbir Singh is there. There also it is saying that the seal cover prosecuted cannot be resorted to indefinitely on the ground that there is a complaint against me in the relevant time. In my case, the relevant time, I had no complaint, Lordship. The judgment I've enclosed, Lordship. But
that is in paragraph C, Janaki Raman is very clear. One thing is preliminary inquiry, that cannot be. That is charge sheet. Once it is charge sheet and trial comes, my lord, we are helpless.
University also has to be dealt with, Lordship, for unnecessary delay, Lordship.
Well, that is not an issue here.
I'll be Lordship.